Resume our hearing.
I had one matter, Madam
Okay,
Examiner,
Ms. Hardy.
and it's regarding a witness availability issue involving Mr. Cunningham.
Okay,
We're planning to have him testify tomorrow toward the end of our presentation, but he is traveling and stranded due to the blizzard. And so we would like to have him testify Wednesday morning instead, along with Miss McArdle. And apologies for the inconvenience.
any chance we can get him today while he's stranded?
He does not have really reliable internet service and does not have his laptop. So
I guess not then, eh?
not the best scenario. We prefer for
Eh,
him not to appear on his
He
phone or
actually
something like that.
travels without his laptop?
He did this time. Very risky.
Uh-huh. Risky during blizzard. Yes.
Yes.
That'll learn him.
Okay. Anybody know who the phone number is? Looks like it is. Looks like it is a local New Mexico phone number. No one's claiming it. Oh, it's Monday. Let's take a chance. Hello, phone number. Who are you, please? Identify yourself. 505-670-1268. Please unmute and identify yourself. Phone number 670-1268. Please identify yourself. You are on mute. Okay, no one wants to claim the phone number. The only procedural thing that that I need to talk about is I want to talk a little bit about our bench request responses. I think one refers to an attachment, and at least the printed version I have doesn't have that attachment. So I want to talk about that. I also want to talk about admitting them. And Hearing Examiner Schaefer, did you have anything procedural we needed to talk about before we begin?
No, just what we discussed about the pending bench requests. That's the only thing I wanted to share with the parties.
Okay, well, I believe we are at 9. Mr. Lee, are we ready?
Yes, Judge.
Okay, good morning. Welcome back to the continuing hearing in case number 25-00066. This is in the matter of SPS, CCNs, and more. We are continuing our hearing, having been recessed Friday evening with hearing examiner Schaefer. And we're back today to continue the examination of SPS witness Cooley. Would like to identify for the record. The phone number is Commissioner Nybert. Hello, Commissioner Nybert. Welcome. And also today with us, we have Commissioner O'Connell. Good morning. And I think, Mr. Cooley, you're in the witness.
I
You're
am
in the
here, Your Honor.
Zoom user. There you are. Good morning.
Good morning, ma'am.
My understanding is that we had reached redirect portion, but I believe Commissioner O'Connell, sir, that you had some questions for Mr. Cooley.
I do, thank you.
Go ahead, sir.
Good morning, Mr. Cooley.
Good morning, Commissioner.
Just had a couple questions for you, and they're relating to SPS or Southwest Power Pool. It seems that, just from my experience and the testimony provided, you're the expert on Southwest Power Pool in this case. So the first one is the island case that's described in Mr. Park's testimony, Southwest Power Pool requirement.
So my understanding, and I did review Mr. Parks's study, what he was looking at was an extreme scenario. I will say that no, that sensitivity that he ran for this case is not a requirement of the Southwest Power Pool.
So then just next question was, why is Southwest Public Service looking beyond SPP requirements as evidence to justify the requests in this case?
Broadly speaking, one, I had no direct interaction with Mr. Parks in the creation of that sensitivity, but from a broad perspective, what I will share is that we as the electric utility industry are starting to see increased extreme weather events driving reliability challenges. We saw this primarily with Winter Storm Uri in 2021. We've seen it with other winter storm activities since then. When we review our planning reserve margin challenges, we see that winter is growing in concern. And so in my opinion, as a prudent utility, we should be looking beyond the minimum requirements to make sure that we have set ourselves and our customers up to be in a position for success, to be reliable, to be able to withstand these events. I think I'll just leave it there.
Yeah, and the confusion in SPS choosing to do this in this case is, broadly the argument for being in a regional organization like Southwest Power Pool is, reliability is cheapest if shared. So why would SPS be not trusting the reliability requirements of Southwest Power Pool, especially in an instance where there's evidence saying these requirements are overly conservative?
So what I will say to that is not the fact that SPS does not trust the reliability requirements set forth underneath the planning reserve margin from the Southwest Power Pool. Again, it's not my testimony nor my study, but I think what Mr. Parks was highlighting was some of the challenges with batteries and that during a prolonged winter storm event, there could be a situation where there's not enough energy on the system due to the batteries needing to, they've been discharged. And if a prolonged event occurs, without thermal resources backing it up, those batteries won't be able to be recharged to then again put energy onto the system to maintain that system reliability. So I would say I don't characterize Mr. Parks's study as disagreeing with planning reserve margins or the need for reliability. I think he was highlighting some of the challenges with batteries through a prolonged winter storm event. And the Southwest Power Pool does not currently have any specific language in their requirements that I'm aware of that states that we need to have X amount of different resources. What we are trying to do as SPS is bring forth a reliable portfolio to serve the needs while keeping an eye on some of those different scenarios that we may be impacted with in the future.
Yeah, I mean, the source of confusion for me is a reliable portfolio that does not seem to benefit from SPS's participation in Southwest Power Pool. That's what the island case leads me to believe.
I guess what I would express is that in Mr. Gable's testimony, he is not creating an islanded case. Mr. Parks's testimony was around some technical assessments, but my understanding is that that's not really what Mr. Gable, who actually performed the analysis identifying the portfolio of the bids that were submitted, was saying.
Yeah, what I found in there was a reason for the size of the ask is a limited import capability that currently exists on the Southwest Power Pool system relative to Southwest Public Service. So there was a constraint in Mr. Gable's work tied to Southwest Power Pool and how New Mexicans are benefiting from SPS's participation in that regional market. Did I misread that?
No, you did not. SPS is subject to limitations in the amount of energy that we can import into our footprint. That is due to the physical characteristics of SPS really being on the edge of the Southwest Power Pools region, as well as the entire Eastern Interconnect. We do have a number of tie lines that connect SPS to the rest of SPP. I do talk about that in my direct testimony, and that limitation that you referred to, we do highlight it as the SPS SPP ties interface. That interface is an established flow gate with the Southwest Power Pool. It has been around, I think, ever since we've joined, or ever since we've been really connected to the other utilities in the Southwest Power Pool. And it has been, that interface and our ability to import energy has grown over the years due to increased tie lines, whether it's 345. We also have 230 kV transmission lines and 115 kV on that interface. But it is, it is a real interface that restricts our ability to import energy. Now, I'm trying to find our exact number. I don't see it in my direct testimony, the exact value, but we are limited. We are not in the middle of the Southwest Power Pool. We don't have significant tie lines going north, south, east, and west. We really only have tie lines to the rest of the Southwest Power Pool through our Texas up into Oklahoma and in Kansas areas. And so we are limited with the amount that we can import, and that does impact the amount of energy we can count on from the rest of the market, or that or for generation that I would say would be physically located outside of our footprint. If we can't import that energy or that capacity during an event, then counting on resources outside of that interface really wouldn't bring a lot of value. I will say that the Southwest Power Pool has identified a new Potter to Beckham 345 kV transmission line that was recently awarded to SPS through a competitive bid procurement. That line will run from Amarillo, Texas into Oklahoma. Studies have not been performed yet, but we do expect that line would provide some benefit and increase to that import limit. Additionally, the Southwest Power Pool has identified an additional 765 kV line running from Oklahoma into the Crawfish Draw area, which is located northeast of Lubbock, Texas. That would also very likely have an increase in our import capabilities. Those studies have not been completed at this time of what the new import limits will be, but as we add more tie lines between SPS and the greater Southwest Power Pool footprint, we would expect our ability to import to increase.
And yeah, that was my understanding also. And does that also include the projects that are moving forward in the two most recent integrated transmission plans?
Yes, sir. The Potter to Beckham 345 kV line that SPS was just awarded was identified in the 2024 ITP. And then the 765 kV line from Woodward to Crawfish Draw, that was identified in the 2025 ITP. That project, the 765 kV line, is expected to be subject to competition issued for RFP later this year.
Okay, thank you. Next question is, are you familiar with the bylaws of Southwest Power Pool's Regional State Committee?
Broadly, yes, sir.
Can you look at your rebuttal testimony at the top of page 6?
Page 6 of my rebuttal. Yes, sir.
Do you believe that testimony that's in that first 9 lines is consistent with RSC's bylaws?
Was ultimately presented to and approved. Sorry, hearing examiner Hurst, you pulled up the bylaws. Okay. Commissioner O'Connell, you're referring specifically, you said, to page 6. I guess maybe starting on page 5, line 17 through line 9 on page 6.
Yeah.
Okay. Sorry, I just wanted to make sure I didn't miss something. Recommended was presented.
Mr. Cooley, there's the bylaws and the governing current.
And since you have it up here,
Yep.
Examiner Hurst, you scroll down to Article 8.
Yes, sir. Article 8.
There you go. Thank you.
Commissioner O'Connell, I have reviewed what is in on page 5 and 6 of my rebuttal testimony, and I agree with what I have written.
Okay. So hearing Examiner Hurst, can we somehow take notice of the RSC bylaws and also of the SPP bylaws in this process?
Any objection to the commission taking administrative notice of the Southwest Power Pool Regional State Committee bylaws, revised November 1st, 2022? Hearing no objection, we will take administrative notice of them. Any objection to taking administrative notice of the governing documents tariff from Southwest Power Pool governing documents tariff, dated April 15th, 2025? Hearing no objection, we will take administrative notice of that tariff from SPP. Commissioner O'Connell?
Yeah, thank you for the assist there, Hearing Examiner Hurst. I'd heard earlier in this hearing you'd been demoted to commissioner, so thank you for helping us out. I don't have any further questions. Good morning and have a great day, Mr. Cooley.
Thank you, Commissioner.
Thank you, Commissioner O'Connell. And I wanted to start off, Mr. Cooley, getting just a clarification, and this actually, I can pull the tariff back up if you want it, but I believe that the very first bench request you answered, and my bench request 1-1 said, is the term deficiency payment defined in the SPP tariff? And you said yes. Your response, it's defined as a payment by a market participant when one or more of its capital L, capital R, capital E, and then plural S, has not met the resource adequacy requirement as calculated in accordance with section 14.2 of this attachment AA. Please refer to page 4 of attachment AA to SPP's open access tariff, transmission tariff provided in exhibit SPS-BR-1. And it has you, Mr. Cooley, listed as a respondent. That was your response?
Yes, ma'am.
Do you know whether or not the actual attachment was included in the bench request response?
It was in the file that I had reviewed. Apologies if it was not actually uploaded.
It might have been that I just didn't print it, and I just wanted to try to get clarification from you.
Yes, so the document is a publicly available document that we had downloaded from the Southwest Power Pool open access tariff. It was supposed to be attached to that bench request, as identified in the bench request response.
Okay, I've got it. Okay, it is. It's a 67-page tariff.
I don't know off the top of my head how many pages it is. It is just the section attachment AA of the tariff, not the entire tariff. It does not surprise me it would be 67 pages long.
Okay. I guess I was saving paper. Let's see. Okay, this is identified as Southwest Power Pool Open Access Transmission Tariff, 6th revised volume number 1, attachment AA resource, attachment AA resource adequacy, attachment AA section 1, attachment AA section 1. So not the whole tariff.
No, just the subsection of attachment AA that outlines the resource adequacy provisions in which the deficiency payment is defined.
Okay.
And I don't have it in front of me, but it should be in the definitions, which is either section 1 or
let's
section
see.
2. I believe I identified it as on page 4.
Is that it?
Yes, Madam Hearing Examiner.
Okay. And I think one of the things that the question was trying to do is to figure out whether or not, well, I think to put parameters on it if it was something that had to be paid because of accumulation of events or just one event at a particular snapshot in time. And I don't know that the specific definition helps me understand that. Can you help me understand it?
I can definitely try.
Okay.
So the Southwest Power Pool to date has now 2 resource adequacy seasons, summer and winter. Summer and winter respectively have their own planning reserve margin requirements. Justin Gable, Mr. Gable, refers to both of those in his testimony. Actually, hearing examiner, you can see right here what you have up on the screen. Scroll down, you can see that the summer resource adequacy season runs from June 1st through September 30th, and the winter season is December 1st through March 31st. And so those are the seasons in which we need to meet the winter planning reserve margin requirement or the summer planning reserve requirement. Leading into those seasons, we are required to fill out a workbook that depicts our resources versus, so our generation assets or interruptible assets versus our load obligation. And that workbook is fairly straightforward conceptually, balancing load versus resources. And you are looking at the upcoming summer season when we're working on it through the first part of the year. And then we're working on the winter workbook more in the fall timeframe. When we think about the deficiency payments have now been my understanding is characterized to whether or not we met the summer planning reserve margin, and there's deficiency payments if you miss your winter requirements. And those deficiency payments are specifically around the outcome of that load and resource table. Did you have enough resources to cover your load obligation? And that is what the deficiency payment is really starts to, it's what it's tied to. So is there multiple other drivers around resulting in the deficiency payment? It really starts to, did you have enough resources to cover your load obligation per the process outlined in the attachment AA of this tariff? And if the answer is no, then that's what triggers the deficiency payment situation.
So it's a determination after the season.
Not after the season. No, the workbooks are required. I believe for summer, we're required to have our workbooks cured, I believe, by May 15th. And after that, and that's forward looking into the expectation of resources and load for that upcoming summer season. And
But-
so,
Well, how are they gonna know you didn't meet it if the deficiency payment situation is, if they determine it before the seasons hasn't terminated?
it is based off of forecasts. So our forecasted load and our forecasted resources as finalized in the workbook, again, subject to check around May 15th. If you are short in that workbook filing, that would then trigger the discussion for deficiency payments. It's based off of forecasts, not actuals.
So, okay, so it's based off of forecasts. Is the determination made before the season begins?
The determination of
Deficiency payment.
the determination of whether you're deficient or not would occur before the summer season. How SPP actually processes that and when they make the determination and when would they actually charge you, I'm not clear. That may be outlined in the tariff. That may be more of a general practices that's maybe not overly prescribed in the tariff. I'm not sure of the timing of when the Southwest Power Pool would enact that deficiency payment discussion. Two things I'd like to add is one, I'm not aware of any utility having been deficient to date. So I'm not aware in the Southwest Power Pool. There was a FERC situation that occurred last year. And I'm not sure if that was there was a FERC item around a utility. The information was not very clear, in which there was a very minor deficiency payment paid, but that was due to some sort of FERC investigation or maybe a FERC audit of a utility. I'm not aware of any utility who has gone into the summer or winter season deficient and had that process work through as it would organically.
Could SBS be charged a deficiency payment for actual deficiency during a particular season?
So not today, we cannot. The deficiency payment concept is based off of forecast.
Right, okay.
I will state that the Southwest Power Pool is looking into conversations. I'm blanking on the acronym at the moment, what it stands for, but it's called PDA. It's not the typical high school PDA, but it's performance of demand response, possibly. I'm blanking on it. I apologize. But Southwest Power Pool is in discussions right now through the stakeholder processes, moving to the board of directors in the regional state committee I believe, in early February around this concept. And that concept will actually be more looking backward about how accurate you were to meeting your load forecast. And so the current provisions in the tariff are forecasted, which is also why, or I would say, allows utilities that failures and situations will occur in reality on units, or load may not materialize as expected, or it will. It is the real world. And when you're creating forecasts, it doesn't always perfect. But this new PDA concept will be more backward looking at how well you did with alignment with your forecast. But that is not currently in effect today. It would need still be approved through the board and the regional state committee, and then move forward to a FERC filing for implementation sometime in 27, very likely.
Mr. Cooley, are you aware of any other regional operator that actually assesses the penalties or payments based on the actual deficiency?
I apologize. Can you ask that question again?
Sure. Are you aware of any other regional transmission organization and their policies?
Broadly,
Okay.
I'm not an expert on plan and reserve margin requirements across the board.
Well, I just wondered if you were aware of any other regional transmission organization that actually it requires deficiency payment or penalty based on actual shortage of a particular utility.
I am personally not aware. I will say that this concept of this PDA concept has resulted in a lot of consternation and concern from utilities of trying to perfectly align a forecast versus actuals, and its impacts on serving loads, serving customers, serving as available. And so I do know that the forecast concept is utilized in other jurisdictions.
Okay.
Never mind. I'll just stop there.
Okay. No, I'm trying to recall the case and I can't. If you're not familiar with it, obviously it was not an SPS case. But I seem to recall some revenue coming in from sharing said type of deficiency payment or penalty from that had been paid in and because the utility had not met required performance. But I believe your testimony is you're not aware of anybody in the SPP having made such a payment, so couldn't have been SPS. Do you think that having this deficiency payment on the front end for the forecast it could incent SPS or other utilities to be overly inclusive with their forecast just so that they're not potentially going to get a deficiency payment?
When you refer to overly inclusive, are you referring to I would take that as meaning adding more. I would say that if you added more load, then your ability to have enough generation to meet that is challenged. So I would say the opposite, if somebody was trying to make sure you're sufficient, would be to actually underrepresent your load, since the generation is typically a more firm, locked in value. I will say that that is not the practice of SPS. We utilize our forecasting methodology, and Mr. Goodenough can speak to that, about how we develop our planning forecast and our financial forecasts, and how those are utilized within our forecasts submitted to the Southwest Power Pool. We do our due diligence on those. And then in regards to the generation side, Mr. Gables, I believe, speaks about this as the accreditation values have been moving over the last few years due to the implementation of ELCC for renewables and batteries and performance-based accreditation for thermal units. And so those numbers on a year by year or season by season basis are nowadays in constant flux. But at the end of the day, all of our data that we submit does get reviewed, can be reviewed by the stakeholder process, by SPP staff, and we are open to talking about, as needed, about why our forecasts or why our resources maybe didn't materialize in real time. And so there are opportunities for questions to be asked of us, whether it's, I would say, by our commissioners or by the stakeholder body of the Southwest Power Pool, if somebody does not feel our numbers line up. We are required, I believe, under our membership agreement to provide accurate information, and we do that to the best of our abilities.
I had a couple of questions, Mr. Coley, with regard to your rebuttal testimony. And you're answering question on page 4, continuing to answer the question posed on page 3, line 8. Please summarize your testimony. And the last sentence on page 4, beginning in line 3. Finally, I explain that while the 765 kV line is an important part of SPS's long-term transmission plan, SPS has not sought an application for approval in this proceeding. And your conclusion is that it's not ripe for consideration. That's your testimony, sir?
Yes, Madam Hearing Examiner.
So my question is, why not? Why haven't you asked? You've asked for everything else in this proceeding. Why didn't you ask for that?
So, ma'am, in this proceeding, Madam Hearing Examiner, in this proceeding, what we are looking for is the generation as identified out of the RFP bid evaluation, and then the subsequent transmission assets as identified by the Southwest Power Pool as necessary for the integration of the Gaines power plant. That would be J41, J42, J43. The 765 kV transmission line was identified by the Southwest Power Pool out of their integrated transmission planning analysis performed at the end of 2024, completed at the end of 2024. SPS did not receive the final notification to construct for that project, I believe, until subject to check. August of 2025. So at this time, we are still working on all the necessary routing and siting and locational details around that proposed project. We do expect to bring the 765 kV transmission line to a future proceeding. But that line currently has a planned in service date of May of 2031. So that line is not specifically, it does not meet the time frame for this case, which we're looking 27 through 2030. We probably will not be bringing that transmission line to this commission until sometime in 2027.
Sir, if you could look at page 10 of your rebuttal testimony, the question posed at beginning at line 3, how do you respond to Mr. Whitney's proposal that SPS provide updated transmission planning sensitivities that exclude or resize the Gain CTG project in the event of an adverse commission order with respect to that facility? And I need some further explanation on your answer beginning at line 12. If the commission were to decrease the size of the Gaines County CTG project due to the tariff requirements outlined in section 4.4 of attachment 5 of the SPP open access transmission tariff, SPS would still be required to build the J41, J42, and J43 segments as submitted in the application. That's your testimony, Mr. Cooley?
Yes, Madam Hearing Examiner.
What's the shorthand on why that section of the tariff would cause or allow the commission to decrease the size of the project?
Two items. I'd like to just highlight that it's attachment V, as in violin, not attachment 5. I think you called it 5, but it's attachment
okay.
V.
Okay.
They do alphabetical for their attachments. And what I'm saying here is I'm not saying that the commission has the ability to decrease the size or they don't have the ability to decrease the size. I'm just highlighting that if the commission chooses to decrease the maximum value for Gaines County, we would still be subject to all the network upgrades currently assigned to the project. So the attachment V of the Southwest Power Pool tariff states that we can only reduce the maximum injection capabilities during the study process. If you look at line 17 on page 10, carrying over into page 11, there's a decision point 1 and a decision point 2, where we can change the size of the request in the DICES study for that generator. We are currently we're past the JEIA phase. We have the generation interconnection agreement in hand. And so if we build less than what was studied, approved, and listed in the generation interconnection agreement, the Southwest Power Pool would just give that capacity back to the system for future studies, but we would still be subject to the network upgrades identified in the analysis. we have seen this happen with wind farms historically, where sometimes they don't build to their full operating capabilities. And so the Southwest Power Pool will actually come back after the fact, after they've been in service for a few years, and ask, are you going to get to your GIA limit? And if the answer is no, the Southwest Power Pool will then reissue a GIA at their current nameplate or injection capability. So entities are not overstating their capacity and actually hindering the ability to perform generation and interconnection studies. Did that help at all, Madam Hearing
Yes,
Examiner?
and I know your testimony at the bottom of page 11, beginning on line 12 through 17. Clarifies. I just want to make sure, because this testimony says an adverse commission decision in New Mexico would not automatically obviate the obligation, referring back to the network upgrades, especially if at least some portion of the proposed Gaines County CTG were to be constructed. Okay, so in order for me to understand this, I just want to ask if the New Mexico Commission disallowed the Gaines County CTG CCN totally, just said no, we don't think that you've proved it, that it's necessary at this time. Would there still be network upgrades necessary to be constructed?
As we are a multi-jurisdictional utility, if one jurisdiction said outright no to a project, but the other jurisdiction did support the project, then underneath our interconnection, our GIA, as well as our obligation underneath the SPP tariff to build the facilities necessary to interconnect that generator, then we would still need to move forward with those network upgrades.
Okay, so this isn't just a case of, oh, well, if New Mexico approved some parts of the Gaines County CTG, but not up to what SPS requested, you would need the transmission segments. But you're saying that even if there was a total denial, if SPS decided to go ahead and construct for if it got approval in Texas, then J41, 2, and 3 still need to be authorized and constructed, correct?
That is correct.
Okay. Okay. And you've already answered my other question with regard to the 765 kV line. I think, Mr. Cooley, that's all I had. I appreciate your time, sir. Thank you very much. Ms.
Thank you, Madam
Hardy,
Hearing Examiner.
you have redirect for your witness?
I do have some. Thank you.
And let me just notify the parties, I made a mistake. I let the next witness in. So if you're, seeing Mr. Dixon, it's because I made a mistake and let him in.
Okay,
Go ahead, Ms.
thank you.
Hardy.
Thank you. Mr. Cooley, regarding Commissioner O'Connell's questions regarding the Regional State Committee, is it SPS's position that the commission is bound by the SPP's determination on the planning reserve margin by virtue of its membership on the committee?
Sorry, can you repeat that question?
Sure. Is it SPS's position that the commission is bound by the SPP's determination on the planning reserve margin by virtue of its membership on the Regional State Committee?
It is our opinion that we are required to meet the planning reserve margin requirement, regardless of whether the commission votes for or against that, if that is the approved value as outlined by the Southwest Power Pool.
And is SPS trying to build a resource portfolio that meets the SPP's planning reserve margin requirement?
Yes.
Regarding the island study, is it your understanding that study was done to pressure test the model in a real-time simulation without being able to rely on the market?
That is my understanding.
Hearing Examiner Schaefer asked you some questions last week about the capacity contribution of surplus resources, and specifically the Sandy Loam project. Do you recall those questions?
I do.
And I believe you had explained that Sandy Loam's accredited capacity is 5 megawatts. Was that correct?
That is what I remember being identified in the study results.
Okay. To be clear, is the expected energy output of Sandy Loam greater than 5 megawatts?
Yes.
You were asked several questions from various parties about surplus resources. To make sure the record is clear, can you please explain what it means for a resource to be surplus?
Yes. I do outline the surplus process in my direct testimony. I believe it starts on page 28. Surplus is a concept outlined in attachment V of the Southwest Power Pool Open Access Transmission Tariff. It's where a utility or an entity that has a generation interconnection agreement already established opens up their point of interconnection to itself, an affiliate, or a third party to also interconnect at that point of interconnection. The purpose of surplus is the understanding that a generation resource is not on 24/7. And so in that all resources, when offered into the market, have different prices. And so surplus allows an entity to connect at the same point of interconnection and hopefully utilize, in theory, diverse resource mixes so that that point of interconnection is used at a higher percentage of the time than a single resource. In my direct testimony on page 28, I provide an example of a wind farm with a nameplate capacity of 100 megawatts would have the rights to inject 100 megawatts onto the transmission system, but it would only ever utilize the 100 megawatts during periods of high wind. During periods of low wind or no wind, those interconnection rights are sitting there unused. And so partnering with a different asset type, whether it's solar, batteries, or thermal resources. And I do want to be clear, surplus does not require the resource to be a different type. I'm just highlighting that diversity of resources can be taken advantage of in a surplus request. But by partnering with solar, batteries, or a thermal unit, the interconnection limit can be used at a much higher percentage of the time.
Are there benefits of having a surplus resource?
Yes. The surplus request does not have any identified transmission network upgrades. The transmission established for that point of interconnection was already bought and paid for by the interconnecting generation entity. And so when a surplus wants to interconnect, there are no transmission network upgrades associated with it outside of the costs for possibly a new interconnection position at the substation or associated relaying. Additionally, it's faster. The surplus interconnection process can take, I believe, somewhere between maybe 6 months to maybe up to 6 months, maybe up to 9 months, while the DICES interconnection process, which is used for new greenfield interconnections to the transmission system, those have taken sometimes up to 5 years in the case of Gaines County between when it was submitted to be studied and when we received the generation interconnection agreement.
You were asked some questions last week by Ms. Lang regarding the cone value. Do you recall those questions?
I do.
And I believe you had stated there was a new cone value.
Yes.
Has that new cone value formula been implemented?
No, the cone value will need to be updated into the Southwest Power Pool Open Access Transmission Tariff. That update has not been filed at FERC, nor been accepted by FERC. So we're still under the existing cone value, but it is expected that FERC will support the updated cone value.
Hearing examiners, I have a couple of questions that I'd like to ask Mr. Cooley regarding items that were referred to him by Mr. Rodriguez in response to questions from Commissioner Connell. Is that acceptable?
Sure.
Thank you. Mr. Cooley, Commissioner O'Connell had asked Mr. Rodriguez some questions about the SPP's determination of the planning reserve margin and what SPS has done with respect to those determinations. My question is this: did SPS challenge the planning reserve margin increase from 12% to 15%?
Yes. Back in 2022, following the winter storm Uri that occurred in 2021, the Southwest Power Pool brought forth a proposal to increase the planning reserve requirements for summer from 12% to 15%. SPS and many other utilities through the stakeholder process challenged the implementation of that planning reserve requirement increase. It was proposed and ultimately accepted by the Regional State Committee to go into effect the following summer. SPS and a number of other utilities and entities supported more of a glide path, a multi-year staging approach. We were unsuccessful in that concept, and the Regional State Committee did approve the 15% value to go into effect the following summer. In 2023, SPS and a number of other utilities did file a FERC complaint around the process and the lack of the planning reserve margin requirements in the Southwest Power Pool tariff. The specific value and the ability to challenge the value are not in the tariff itself, just the concept We were unsuccessful in that FERC complaint. FERC did recommend some changes to the Southwest Power Pool tariff to provide more guidance around the methodology, but we were unable to get the exact value put into the tariff, which would allow us opportunities to appeal in the future.
Mr. Rodriguez was also asked about whether SPS has tried to obtain or can obtain a waiver from the SPP planning reserve margin, and he deferred those questions to you. Is it possible for SPS to obtain a waiver from the SPP planning reserve margin requirement?
Similar to the following the 2022 planning reserve increase from 12% to 15%, there were significant concerns from stakeholders around the process, primarily around how quickly a planning reserve margin increase could be implemented onto load responsible entities. And the Southwest Power Pool Board of Directors took initiatives to identify some possible solutions to alleviate those concerns with stakeholders. One of the concepts was the creation of a waiver process with some, obviously requirements needed to be done upfront by utilities to prove that they couldn't meet, but they tried the best they could to meet that planning reserve margin requirement. The waiver process, although approved by the stakeholders, was ultimately rejected by FERC. So to date, there is not a provision in the Southwest Power Pool open access tariff for a waiver of planning reserve margin requirements. If a waiver was requested, it would have to be at FERC.
Thank you. Those are all of my questions.
Thank you, Ms. Hardy. Commissioner O'Connell, do you have any follow-up on Mr. Cooley's answers to the questions that were deferred from Mr. Rodriguez?
No, I don't. Thank you.
Thank you, Commissioner. Does anyone have Hearing Examiner Schaefer, do you have any questions for Mr. Cooley based upon his redirect to the questions that you asked?
No, I do not, Madam Hearing Examiner. Thank you.
Thank you, Hearing Examiner Schaefer. Any party have questions for
Yes, ma'am. Staff does.
Mr. Cooley based upon Commissioner O'Connell's questions or my questions or the redirect? Ms. Lang,
Yes,
go
ma'am.
ahead.
Thank you. Mr. Cooley, I think I have two questions.
Good morning, Ms. Lang.
Good morning. Sorry, I had a bout of the flu over the weekend, so this is NyQuil, so I'm sorry. I was trying to get to the questions. Are you aware that in the current SPS rate case before the commission, that is specifically case number 250079, SPS is seeking recovery for the deficiency payments?
Subject to check on the case number, I am aware that we are requesting recovery of deficiency payments or a process for that.
My next question is, this is actually me trying to, because I might have misheard. Did you say that SPS tried to intervene or did not intervene in the FERC case where the winter reserve margin was established at 36%?
I did not answer that question today.
Okay.
Um,
I think it was a question of if you I think the question was, did you try to, okay, so I guess I'm going to ask you, did SPS intervene in the FERC matter that raised the winter PRM to 36%?
It is my understanding that we did intervene. I do not remember off the top of my head our level of intervention, whether we filed comments or we were just intervened in that case. We definitely, one thing I want to highlight is that the value of a planning reserve margin requirement, the PRM itself, as I answered previously, is actually not in the tariff itself. So challenging the exact number is extremely difficult once it's approved by the regional state committee. There's not a value to go after at FERC in a complaint. You have to go after the process itself. So we definitely advocated in the stakeholder processes for a lower planning reserve margin than 36% for winter when it was originally developed. SPS advocated for a 33% planning reserve margin requirement for winter based off of the evidence and the numbers performed in the study. SPP staff and some others advocated for the 36% value, and that was the value that was ultimately approved by the regional state committee.
I'm just pulling up discovery responses. This is SPS's SPS's discovery response to staff's third set of interrogatories. I think I can confirm that SPS did not intervene in the FERC proceeding, and you already answered why, even if you did say that you did. But I guess my question is, in the preliminary proceedings before it got to FERC, did SPS what steps did SPS take to question the increase or mitigate the increase in the winter PRM? Do you know?
Madam Examiner,
Ms. Hardy?
I object to Ms. Lang reading a discovery response into the record that's not in front of Mr. Cooley, and I don't know exactly what it says.
Ms. Lang? Did you put this in the Dropbox?
Yes, ma'am, it should be in the Dropbox. But I will let me find it.
What number?
Let me pull it up real quick. Madam Hearing Examiner, it's going to take me a while, so I withdraw that question.
Okay, go ahead.
I have another question, Mr. Cooley. Bear with me. Okay, I think that's actually all I have. Thank you for your time.
Thank you,
Thank you,
ma'am.
Ms. Lang. Anything further? Okay, hearing no questions. Mr. Cooley, thank you, sir, for your time. You are excused.
Thank you, hearing examiners.
Ms. Hardy, you have another witness. I think it's Mr. Dixon.
That would be correct, Madam Examiner.
Hello there, Mr. Dixon.
Morning.
How are you?
Good. How are you?
I'm okay. Mr. Lee, would you please swear in the witness?
Mr. Dixon, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter now pending should be the truth, the whole truth, and nothing but the truth.
I do.
Thank you, sir.
Thank you, Mr. Lee. Go ahead, Ms. Hardy.
Thank you. Mr. Dixon, can you please state your name for the record?
Brad S. Dixon,
By whom are you employed and in what capacity?
XL Energy Services as a siting and land rights agent.
Do you have in front of you a document that is marked as SPS Exhibit 23?
I do.
What is that document?
It is the direct testimony of Brad S. Dixon on behalf of Southwestern Public Service Company.
Was it prepared by you or under your direct supervision and control?
Yes.
Are there attachments to your direct testimony?
Yes.
Were those attachments prepared by you or under your direct supervision and control?
Yes.
Is your testimony true and correct to the best of your knowledge?
Yes.
If you were asked the questions in your direct testimony as you sit here today, would your answers be the same?
Yes.
Madam Examiner, I move the admission of SPS Exhibit 23.
Any objection to what's been identified as SPS Exhibit 23, the prepared direct testimony of Mr. Dixon as affirmed by him here today? Hearing no objection, SPS Exhibit 23 is admitted. Ms. Hardy?
Thank you. Thank you. I have no further questions for Mr. Dixon. He's available for cross-examination.
Thank you very much. I believe that the only party that requested to cross-examine Mr. Dixon was staff. Ms. Lang, Ms. Aver, I believe you reserved 5 minutes.
Yes, ma'am. No questions for Mr. Dixon, but I would like to move that 5 minutes to Mr. Lytle, please. Thank you.
I just have a couple of questions for you, sir. It seems as if with the process of routing and site development that there's at least 4 witnesses in this case that testify about that. Is that correct?
I am not sure.
Well, we
In the
have you
routing,
and I already heard from Ms. Fleshman,
yes, ma'am.
and then I'm gonna hear from Ms. McCardle.
Yes, ma'am.
Okay, so that's 3. Was there another one?
Not that I'm aware of.
Okay. Can you just generally differentiate the differences in your 3 roles?
Me and Miss Fleshman would be generally the same. She is more on J43, whereas I am working on J41 and 42. Ms. McArdle is our environmental consultant for all 3 of those lines.
Okay. And I note in your testimony that you indicated that for J41 and 42 that these particular transmission line routes crossed already owned SPS land and or private land. Is that correct?
Yes, ma'am.
And so no state-owned land or no federal-owned land, correct?
Not for J41 or 42.
Okay. And I heard from Ms. Fleshman the other day, but since these 2 are yours, have have you completed your negotiation for the private, contracts for these two lines?
No, ma'am.
But are you in the process of negotiating them now?
On some of them, yes, ma'am.
Do you have a target date for completion?
Of the property rights,
Yes.
I believe we're looking for around Q4 of this year, I believe.
So then it's fair to say that you're either in the process of trying to wrap these up, or you'll begin a more active period then?
Yes, we would start working on them more heavily after approval of this hearing.
Okay. And you indicated that you completed your public meeting requirement, and had your public meeting in Eunice, New Mexico, is that correct?
Yes, ma'am.
And did SPS or other SPS customer or other commenters show up for that hearing?
Yes, ma'am.
So you did get some public comments?
I did not get any public comment for J41 or 42.
So you got public comments, but they weren't specifically for J41 or 42.
Correct.
What were they on?
I believe Ms. Fleshman had a few on J43.
Okay. And then with regard to any type of final compliance requirements, you testify on page 17 of your testimony that you are coordinating with the Lee County Soil and Water Conservation District with regard to certain, I guess, requirements with regard to vegetation management and erosion control practices.
Yes, ma'am.
Do you have to get a permit or, sign into some type of agreement with them before actual construction on the project begins, if approved? Projects.
I'm not aware of an actual agreement. It's more SPS would let them know what our practices are and if they would require anything different or special for these projects, then we would comply.
Okay. Any other road or construction permitting necessary that you're still working on?
Yes, ma'am, from New Mexico DOT and Lee County as well.
And is that something, again, that you actually have to have some type of permit or affirmative agreement to let you go ahead with the project? if approved?
Yes. Both
When
of
do you
those would
expect to get
have,
those? Okay,
both of those would be done prior to construction and after location approval.
okay, but, no need to expend those efforts until you get approval from the commission?
That's correct. They have a short time frame be utilized before they expire. So we get those generally right before construction.
Very well. Thank you, Mr. Dixon. That's all I had. Ms. Hardy, anything further from Mr. Dixon?
No, thank you.
Thank you. Hearing examiner Schaefer, any questions for Mr. Dixon?
Nothing for me, thank you.
Okay, I'm not seeing anything from any of the other parties. Mr. Dixon, appreciate your time, sir. You're excused.
Thank you, Madam Hearing Examiner.
Thank you. Ms. Hardy, you have another witness.
We do. SPS, the next witness is Mr. Mark Lytle, and Mr. Skinner will be presenting Mr. Lytle's testimony.
Okay, very well.
Good morning, Madam Hearing Examiner, and good morning, Mr. Lytle.
Good morning, Mr. Skinner. Good morning, Mr. Lytle. Welcome.
Thank you.
Mr. Lytle, if you could please state your full name for the record.
Joel Mark Lytle.
By whom are you employed and in what capacity?
Excuse me, Mr. Skinner, may I swear the witness?
Of course, yes, thank you.
Go ahead, Mr. Lee.
Mr. Lytle, will you please raise your right hand? You solemnly swear the testimony you're about to give in the matter of penny should be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you, sir.
Thank you, Mr. Lee. Go ahead, Mr. Skinner.
Yes, thank you, Mr. Lee, and we'll start over for the record. Mr. Lytle, could you please state your full name?
Joel Mark Lytle.
By whom are you employed and in what capacity?
XL Energy Services. I'm the director, or capital director for the SPS region for the major projects group.
Do you have an exhibit marked, do you have an exhibit before you marked as exhibit SPS 11?
Yes, sir.
Could you identify that for the record, please?
That's the direct testimony in this case of my direct testimony in this case.
Does that direct testimony also have attachments to it?
It does.
And was this testimony and its corresponding attachments prepared by you under your direct supervision and control?
Yes, this was originally prepared by Brad Morrison. I have made some updates to it in the revised. This is a revised testimony and have adopted everything in here as mine.
If I ask you the same questions that are in this direct testimony today, would your answers be the same?
Yes, sir.
Do you have any corrections or updates to make to this testimony at this time?
Yes, I do.
If you could first turn with me, please, to page 6, line 4 of your testimony.
Mr. Skinner, are these substantial corrections that we're going to read into the record?
That would be the preferred course of action, Hearing Examiner Schaefer. They're, I think, minor in the overall grand scheme of things, but they're not mere typos. At least a couple of them are not.
I believe that also there's substantial revisions to the rebuttal testimony. Is that correct?
I don't believe there are any substantial revisions to the rebuttal, just to Mr. Lytle's direct.
Just to direct, okay.
Yes.
I'm just wondering if, just for, rather than read through line by line all the corrections, if any parties object to accepting the corrections as uploaded to the testimony in the Dropbox.
And Your Honor, to clarify, the version in the Dropbox would need to be updated for these handful of minor corrections. The version up there currently does not reflect them.
Okay, please proceed, Mr. Skinner. Thank you.
Okay, thank you. Mr. Lytle, on page 6, line 4 of your direct testimony, do you have a correction to identify there?
Yes, in this section here, the answer for this question, it says the 4 proposed wind and solar projects. That should be restated to say 3, as the Oneida project has been pulled from this proceeding.
Thank you, sir. Could you then turn with me to page 37 of your direct testimony?
Okay.
Line 12, do you have an update to that line? Or the sentence starting on line 11, but an update to line 12.
Yes, the it says the Sandy Loan project will I need to add the word likely also be eligible for the energy bonus credits.
Okay.
And then, okay,
Go ahead. And then line 14.
in line 14, it says Tolk, a coal-powered generating facility, will be retired near to Sandy Loam's COD. Those CODs don't quite match up. So
Okay, so replace
replace
prior to.
with near.
If you could then turn with me to page 56 of your direct testimony. Line 1. Do you have an update to that line?
It says identified in table BDM-9. I need to add and meet the other components I previously described. So
Thank you, sir. And then finally on page 57, line 7.
as each of the proposed wind, solar, and best project will.
Sorry, sir, could you start again and slow down?
Okay. I need to add the term after will to put seek to qualify for energy community bonus.
Thank you, sir. And Mr. Lytle, with those corrections, if I asked you all of the questions in your direct testimony, would your answers today be the same?
Yes, sir.
And are they true and correct to the best of your knowledge?
Yes, sir.
Okay, Madam Hearing Examiner, with that, SPS would move for admission of Exhibit SPS 11.
Were there attachments, Mr. Lytle, to your adopted testimony?
Yes, ma'am.
And since you're adopting this, were they prepared by you or under your direction and control?
They were prepared prior to me adopting this, but I have reviewed them and they are correct.
Okay. And how was Mr. Morrison related to you in the organizational scheme of?
He was the director of renewables for generation development. I am a peer to him in the execution side of this of building new generation. So the projects he develops, would have developed, him and his team would come over to me to actually build those. Prior to in previous CCNs and rate cases, I had both of those roles were rolled under me. They have been split out and separated out for in a reorganization that took place in the recent past.
Okay.
He's no longer with the company. He left the company.
Okay. Any objection to what has been identified as SPS Exhibit 11, the second corrected direct testimony of Mr. Lytle as corrected by him here today? Is that the correct description, Mr. Skinner?
I believe it is, Madam Hearing Examiner. Thank you.
So am I to understand that the second corrected direct testimony of Mr. Lytle that's in the Dropbox is going to be replaced?
Madam Hearing Examiner, we're happy to proceed in the way that you would direct with respect to putting in writing the handful of minor edits that Mr. Lytle identified on the stand here today. So we're happy to make that that update and then upload a corrected version of the file if that's your preference.
It is?
Okay, then we will get that done.
Okay. Okay. Any objection to SPS Exhibit 11, the second corrected direct testimony of Mr. Lytle, as corrected and affirmed by him here today? Hearing no objection, SPS Exhibit 11 is admitted upon condition that the corrected version of Exhibit 11 be entered into the Dropbox before close of business today. Go ahead, Mr. Skinner.
Thank you, Madam Hearing Examiner. Mr. Lytle, do you also have before you an exhibit that's been marked as Exhibit SPS 12?
Yes, sir.
And can you identify that for the record, please?
That's my rebuttal testimony in this proceeding.
Any attachments to that rebuttal testimony?
No attachments.
And was this document prepared by you or under your direct supervision and control?
Yes, sir.
If I asked you those same questions today, would your answers be the same to the best of your knowledge?
Yes, sir.
With that, Madam Hearing Examiner, SPS moves for the admission of Exhibit SPS 12.
Mr. Lytle, are the answers contained in SPS Exhibit 12 true and correct to the best of your knowledge?
Yes, ma'am.
Any objection to what's been identified as SPS Exhibit? Do you have any corrections, additions, or deletions to that testimony?
No, I do not.
Any objection to what's been identified as SPS Exhibit 12, Mr. Lytle's rebuttal testimony as affirmed by him here today?
Your Honor,
Hearing
Nick Stoffel.
Mr. Stoffel.
Yes, good morning.
Hi, how are you?
I'm doing well. No objection to the testimony. I note the version that was uploaded to Dropbox actually has the certificate of service embedded in the middle of the testimony. And so I don't know if you'd like to have a corrected version with that formatting issue uploaded as the official record here.
Mr. Skinner, do you want the official version of SPS 12 to have the certificate of service right in the middle?
Thank you, Mr. Stoffel. Yeah, that's a good point, we are happy to make the corresponding reordering of those pages, Madam Hearing Examiner, in connection with the uploading of the second corrected direct testimony of Mr. Lytle by the close of business here today.
Very well. Thank you, Mr. Stoffel. The reordered version of SBS Exhibit 12, the rebuttal testimony of Mr. Lytle as affirmed by him here today, and subject to entry by the close of business today. Hearing no objection will be admitted. Mr. Skinner?
Thank you, Madam Hearing Examiner. No further questions for Mr. Lytle at this time. He is available for cross-examination and questions from the hearing examiners and commissioners. Thank you.
Thank you so much. Mr. Stoffel, I believe you're the only party that reserved cross-examination time for Mr. Lytle. And if I'm correct, you reserved 20 minutes.
We did have 20 minutes. I'm not sure if we're the only one, and I don't expect we'll need all 20.
Very well. Oh, I think Ms. Lang, you moved your 5 minutes to Mr. Lytle from Mr. Dixon.
Madam Hearing Examiner, we had reserved 20 minutes for Mr. Morrison, so I would go to Mr. Lytle.
Okay, so you have 25 minutes now.
I think so, and I would like to also move the 2 5-minutes from each from Park and Fleischman to Mr. Lytle as well. Okay, so I think I have 35.
Okay,
Thank you.
very well. Go ahead, Mr. Stoffel.
Thank you. Good morning, Mr. Lytle.
Morning.
For the record, I'm Nick Stoffel, one of the attorneys representing the New Mexico Large Customer Group in this proceeding. I'd like to start our discussion this morning with the corrections made to your direct testimony through the second errata and during the introduction of your testimony here today. So looking at page 54 of the PDF of your direct testimony, that's page 46 of the testimony itself. So there on line 4, the testimony was changed from saying that the Plant X BESS would qualify for the eligible community bonus tax credit to saying that it might. Is that accurate?
Yes, sir.
And then the same with the change made on line 9.
Yes.
And earlier during the introduction of your testimony, you made a similar change regarding the Sandy Loam project as discussed on page 37, line 12, correct?
Correct.
Now, the modeling performed by SPS in the selection of the Plant X BESS and the Sandy Loam project assume those projects would qualify for the community bonus tax credit, right?
Yes, sir.
Now, turning to your rebuttal testimony, you responded to the NMLCG's recommended performance guarantees, right?
Yes, sir.
And specifically, it's your position that the guarantees are not appropriate in this context because the self-build projects are primarily built to meet a capacity, not a production need, correct?
That is one of the reasons. Yes, sir.
And you are aware that the amount of accredited capacity SPS receives from the SPP for renewable resources and battery storage facilities depends in part on how those resources perform over time, correct?
Could you repeat that?
You are aware that the amount of accredited capacity that SPS receives from the SPP for the renewable resources and battery energy storage resources depends in part on how those resources perform over time, correct?
I believe that to be true. Yes.
And whether the forecasted benefits from production tax credits and avoided fuel costs actually materialize also depends on how those resources actually perform over time, correct?
Yes, those credits are based on generation.
And you also argue that the performance guarantees are unnecessary because customers are protected from imprudent costs through the rate making process, right?
That is one of the ways they are, yes.
And you argue that the commission can disallow recovery if it determines that SPS's investment was not prudent, correct?
Yes, sir. They have that right.
Do you understand the determination of prudence to be a one-time occurrence, or are investments reevaluated by the commission for prudence over time?
I don't know that have the expertise to answer that. I'm not a regulatory guru for sure.
But it's your testimony that customers are protected through the regulatory process, right?
Yes, all of these projects will come before the commission again and a regulatory filing, and prudency is part of that.
So let's assume for this discussion then that the determination of prudence is a one-time occurrence, okay? That would limit the commission's ability to evaluate prudence based on how the resources actually perform over a period of time as compared to the modeling assumptions used to select the resources, right?
I'm not sure I know the answer to that.
Well, so if the commission can only evaluate the determinant of prudence one time, that would be done when those resources are first being introduced into rates. Would you agree with that?
That is, that does happen during a rate case. Yes.
And so then if that is happening during the first rate case where those projects are eligible to be brought into rates, and it is a one-time determination, that would prevent the commission from evaluating prudence in the context of how those resources performed over a longer period, for example, over 10 years, right?
Yeah, I think as I answered earlier, I don't know that I know how that is handled over time. I don't know that that would probably be best answered by Mr. Cunningham. He's kind of the policy witness coming up on the agenda later.
So just to make sure we're clear on your testimony here today, in your filed testimony, you represent that the performance guarantees are not necessary because customers are protected through the rate making process, which includes a determination of prudence, but you don't actually know how a determination of prudence works before the commission.
I do understand how the determination of prudence in a rate case works.
Right.
And one of those, that's one of the ways, one of the reasons why, performance guarantees really don't work for these projects. There's other reasons as identified in my rebuttal testimony as well.
Well, that's what I'm trying to clarify. So it's your testimony that performance guarantees are unnecessary because customers are protected through the prudence determination. But if the prudence determination is made once in a project's life, that prevents the commission from reevaluating whether that investment was prudent based on whether it actually performed as expected over a longer period, right?
Like I said, I don't think the ongoing prudence determination of the ability of the commission to review those in the future, I do not know the rules and regulations around that, how that can or would happen.
As far as you know, SPS expects to recover the cost of the self-build projects through base rates, correct?
I believe that's right.
They're not planning to recover those costs through a power purchase agreement, right?
No.
And would you agree that the revenue requirement for the fixed costs of the self-build projects does not vary with the performance of the resources?
I don't believe so.
In contrast, under a power purchase agreement, a developer assumes the risk of a resource's performance, right?
Do not know how purchase power agreements are built and how those are enforced. That's outside of my realm of expertise.
So in your rebuttal testimony, you argue that the production guarantees are not appropriate because SPS largely does not control the output of those resources, correct?
That is true.
And the factors that impact renewable output also impact renewable projects owned by independent power producers, right?
I could see that being the case.
SPS did have control over how it estimated the performance of the self-build resources when evaluating project bids, right?
The proposed or the estimated production was part of the bids that went in. How those were utilized by the evaluation team, I'm not aware. I don't understand. I don't know that I know that answer, exactly how those were used.
You're aware that the evaluation team was comprised of personnel from SPS, right?
Correct.
The existence of production tax credits helps to reduce the risk of underperformance since those resources are bid at a negative cost into the SPP integrated marketplace, correct?
That is true.
Thank you, Your Honor. I have no further questions, but I would move to strike Mr. Lytle's testimony that relies on the rate-making process as a customer protection and a reason for why the performance guarantees are unnecessary, given his lack of knowledge to actually be able to articulate and explain how the prudence process works and whether that actually provides equivalent protections to the proposed performance guarantees.
What specific testimony are you seeking to strike, Mr. Stoffel?
Well, it's in his rebuttal, and it's any reference to the prudence process and rate-making process providing sufficient protection in lieu of the performance guarantees. If I could have a moment, I could give you the specific page and line references.
Very well.
Your Honor, may I respond?
I need to see what he wants to strike first, sir, before.
So I would strike page 11 of the PDF, that's page 8, lines 3 through 7.
Very well.
And page 5, line 15, starting with and through 16 ending rate cases.
So page 5, line
15, starting with and through 16 at the end of that sentence, through rate cases at the end of that sentence.
Okay.
And then, as I said, line 8 or page 8, line
3 through 7.
Through 7, correct.
Mr. Skinner?
Yes, thank you, Madam Hearing Examiner. I'd say, first of all, Mr. Lytle has sufficient experience that he identified as being both a rate case witness and a bid witness in prior proceedings to testify on the subject that Mr. Stoffel has identified. Secondly, I think the portions of Mr. Lytle's testimony here today that Mr. Stoffel is referencing were based on a hypothetical of some future prudency review that would go on after an initial base rate case. That indulging in that hypothetical or being unable to answer that hypothetical by no means disqualifies Mr. Lytle's testimony regarding the ability of the commission to review the prudence of these projects in the initial base rate case in which they'd be brought. Further, it is completely unnecessary to strike that testimony. If anything, it goes to the weight.
Permission to respond?
Yes, sir.
I only asked those questions in the context of a hypothetical when the witness acknowledged that he did not know if a prudence review was a one-time occurrence or an ongoing occurrence. The comparison of a prudence review to the performance guarantees, which would apply over time, depends on the answer to that question. Because this witness has raised the prudence review as a reason why the performance guarantees are not necessary, but lacks the personal knowledge about how a prudence review at the commission actually works compared to the proposed performance guarantees, it is appropriate for that testimony to be stricken because he does not have the personal knowledge to explain it when tested during the hearing.
Madam Hearing Examiner, permission to respond.
Go ahead, Mr. Skinner.
I don't know that anybody has the ability to speak to a hypothetical in which a subsequent prudence review would occur after a base rate case, because that's not in fact how prudence reviews occur. And so I don't know that anybody's going to have the personal knowledge to be able to answer that hypothetical.
And again, permission to respond.
Go ahead, sir.
The hypothetical was raised because the witness did not know that a prudence review was a one-time occurrence, as confirmed by Mr. Skinner here. And that's why the hypothetical was discussed. So if the witness actually had the personal knowledge to be able to explain how a prudence review is or is not like the proposed performance guarantees, that would be correct. But he confirmed on the record today here he did not know.
Very well. I'll take this matter under advisement, and I believe, Mr. Stoffel, you indicated that was all the questions you had for Mr. Lytle, correct?
That is correct. Thank you.
Very well. I think it's a good time for our morning recess, and I've got 10:52. So why don't we come back at 11:02, and I believe Ms. Lang will have questions at that time. Please remember that the YouTube is on. Thank you. Very well. Mr. Lee, are we good to go?
Yes, Judge.
Very well, sir. Thank you. Hearing examiner Schaefer and I have conferred with regard to the motion to strike the page 5, lines 15 and 16, and page 8, lines 3 through 7. After reviewing those passages and the witness's testimony with regard to those sentences, we're going to deny the motion to strike. We believe that the nature of the written testimony, as well as his responses to the cross-examination, will provide a sufficient understanding and weight for us to understand that testimony. Ms. Lang, you reserved 35 minutes.
Yes, ma'am. I hope to not use up all of it.
Very well. Go ahead, please.
Thank you. Good morning, Mr. Lytle. How are you
Good
today?
morning. Very good. Thanks.
I had a question. In your rebuttal, you say that you're the director of regional capacity projects. Is that correct?
Regional capital projects.
Capital
Yes.
projects. Okay.
Yeah.
How long have you been in that role?
9 years.
That's a long time. Thank you. I have a question about
Excuse me, Ms. Lang, sorry to interrupt. Please, let's just make sure to ask questions. While this is a question and answer, we should limit conversational asides. Thank you.
Thank you. Mr. Lytle, in your opinion, does a higher PRM at the load serving entity result in lower wholesale market energy prices?
That's way outside of my expertise on operations and that type of thing. I don't think I can comment on that.
Okay. Do you know if the SPP has a capacity market?
At a high level, I'm aware that they do have capacity market that but exactly how it works and that type of thing, I'm not aware of.
My next question is, are you aware that the initial fleet of the 4-hour BESSes in PNM territory has an ELCC that's efficient load carrying capacity of 85%?
I think the specific number, I know it's a high number. I don't know if that 85. I can agree with that. That's probably correct. Yes.
With regard to BESS accreditation, in your opinion, would the inclusion of more historic data move the accreditation numbers?
Objection.
Mr. Skinner?
This is outside the scope of Mr. Lytle's testimony.
Ms. Lang?
Seeing that he is the director of regional capital projects and his duties include capital execution of SPS's major projects, which necessarily would include battery accreditation and how batteries are managed, and how that affects what projects are sought after. I think it's well within the scope of his expertise.
Mr. Skinner?
Mr. Lytle does not testify with respect to the exact process by which SPP does or does not accredit these projects.
May I respond?
Yes.
But that doesn't the accreditation of SPP with regard to things like batteries necessarily influence how capital projects are sought?
I believe you're correct, Mr. Skinner. I don't believe that the scope of his testimony includes testimony about the specific SPP process. To sustain that objection, Ms. Lang, move on.
Thank you. Mr. Lytle, you would agree with me that the capacity portion of capital expenditures in this particular matter are placed into rate base.
If what you're asking is the approved projects that in this portfolio that get approved and get built would go into rate base, and they would fulfill some capacity requirements for the system, the SPS system. That's a true statement. If that's what you asked.
That is what I'm asking.
Yes, ma'am, that would be true.
Wouldn't you agree that if that is the case, a good portion of the capital projects are funded by ratepayers' monies?
Could you say that again?
If that is the case, which you said it is, would you agree with me that a portion of these new projects that will fulfill capacity needs is funded by rate-based monies?
Yes, these projects, if approved, and those would be included in a future rate case to be evaluated for prudency at that time. And at the end of that rate case, those would be incorporated in the rates for the customers for the various jurisdictions.
Do you know, Mr. Lytle, if there is a national standard for calculating the ELCC for energy storage?
I do not. That's I think that's an SPP. That would be another SPP question that how they developed that and how they got that approved is, I'm not an expert in that. No, ma'am.
Do you know who that might be?
Jared Cooley and Justin Gable are the two that would know that. I think there was some questions asked both of those and around that topic.
Let me just look at my notes. That's all I have for you. Thank you very much.
Thank you.
I do not believe that any other party reserved cross-examination time for Mr. Lytle. Hearing Examiner Schaefer, do you have questions for Mr. Lytle?
Thank you, Hearing Examiner Hurst. I do, but I believe Commissioner O'Connell might have one or two questions for the witness.
Very well. Commissioner O'Connell?
Thank you. Just one question. Good morning, Mr. Lytle.
Morning.
I'm going to reach you back into Mr. Morrison's testimony. So if you could open up page 3, line 2.
Okay.
Could you tell us what steel for fuel means?
Okay. I'm probably looking, I'm on page 3. I don't see that in my version here.
It may be helpful to clarify, Hearing Examiner Hurst, if you'll indulge me for a moment. I believe the steel for fuel discussion may have been in the introduction to Mr. Morrison, his bio. And so
Oh,
in the version on the Dropbox, Mr. Lytle's bio has replaced that. But I just wanted to make that clarification in case that was helpful to the extent that passage was not being located.
Appreciate that, Mr. Skinner. I'm not trusted with Dropbox.
Me neither.
me neither.
So, okay, then let's just broaden it out. You already testified that your position was a peer to Mr. Morrison when he was there. In his testimony, his introduction, he talked about how he'd worked on Excel's Steel for Fuel initiative. Do you know anything about that initiative?
Yes, sir.
Could you describe it?
Yes, that was a initiative, probably, I don't know the exact dates. I know it was a push by the corporation for us to basically capture some of the production tax credits and reduce our customers' overall cost. So what happened as a result of the Steel for Fuel initiative was we installed new infrastructure, and for the Hale and Sagamore wind farms back in the 2018 through 2020 timeframe. So those were projects that were justified economically, that made sense for us to build those wind farms, to get those in service, to start capturing those PTCs and reduce our overall cost for generation. So the fuel part of it is, we have a wind farm there that's generating. It's an intermittent source, but when it generates, we're going to gather PTCs, and we're not going to buy fuel to generate those megawatt hours. And we're going to offset fuel usage at some of our conventional power plants, whether coal or gas-fired power plants. So that was the initiative back in the day that ended. There was a series of projects across all four of our jurisdictions, NSP, Public Service of Colorado, and SPS. So that was part of that. So that's what that's referencing, is the first extensive build out of primarily, they were all wind generation projects.
Yeah, thank you. Would the cost savings include also variable O&M?
Correct. In the event, a lot of the variable O&M that goes along at a coal plant or a gas plant, there are fixed costs, fixed O&M costs, and then the variable are things like, you have to do overhauls based on number of hours of runtime. You delay that time, you spread that out over a longer period of time. You have chemical usage, which is a big driver in O&M cost at some of those facilities. All that variable does, the less they run, the less variable O&M that does hit it. Yes, sir.
Great, thank you. And then, again, sorry, because didn't realize you didn't have Mr. Morrison's testimony, but he talked about how that initiative was recently completed. So I was wondering if that also completes Xcel Energy's goal of reducing cost by offsetting O&M and fuel cost with steel.
Yeah, you have limited opportunities now, because now we need the generation. We were able to add wind generation or renewables generation to get the PTCs. But now we're in a new phase of having to replace some of those facilities like Tolk. Tolk is being replaced with projects in this portfolio. There's not as much of an opportunity there to offset the fuel part because we need the generation we have. We're going to extend some of the units that Mr. Tucker talked about yesterday, trying to get those to extend to limit the capital investment, to help us manage the system. But some of those steel for fuel opportunities are going away just because of the age of our fleet and the growth associated with the region.
So in this instance, we have a few facilities that sound like steel for fuel proposals that are surplus, right? They're put
Correct.
behind existing interconnection. And my understanding of surplus is the ability for some of these facilities to produce might be limited because the facility in front of it is on. So was there any look at optimizing this steel for fuel concept when choosing whether to make something a surplus interconnection or a standalone so it could freely supply energy?
Yes, in this particular portfolio, I think everyone's aware. You're aware of the DISIS quagmire, whatever you want to call it, of getting new generation interconnect. That's such a long-term process. I think Mr. Cooley talked about, a 5-year or over 5 years historically is what that's taken. So for us to get projects in and bid into this RFP, we looked at surplus as the option. Now, operationally, when we get to it, some of the way we're going to get to operate the system, if the portfolio is approved as it is, as proposed, those surplus interconnection will be bid into the market. I think those will be bid in and they will be at a very low cost. So when those resources are available, they'll get picked up first, and then the resources that have the interconnect that are not the surplus, that are the primary generation interconnect, can pick up the pieces at to maximize our interconnect. So in theory, the reason the surplus projects got selected was their low cost in the future with the tax credits. That's a big driver. So they're going to be bid in negative. So they'll be picked up. If it's just purely on economics each day, they'll be picked up first. You won't run a gas plant. You'll use the wind or the solar or whatever, the surplus primarily. But then the other unit, say a unit like Plan X Unit 4 could run at night when the load is heavy in the winter, when the solar farm is not outputting. So you're going to be offsetting fuel. It's just not quite as direct one for one like the Steel for Fuel initiative was, where it's, if this makes a megawatt, this one's not, because there's going to be sometimes, because of system reliability, the primary interconnect facility will have to be on and running and may prevent the other surplus from being utilized 100% when it's more cost effective, just for system reliability.
Thank you for that explanation, and thank you for pulling double duty here with me, grabbing testimony that's not even here. So
Sorry.
that's all my questions.
Thank you, Commissioner. Hearing examiner Schaefer?
Yes, thank you. Good morning, Mr. Lytle. Thank you so much for being here with us today. I just have a few questions. Firstly, can you explain for us the relationship between your team and the scope of work of your team and that of Mr. Gertz?
Well, we're kind of, like I explained, I have a different role from Mr. Morrison. His role is the equivalent of Mr. Gertz for renewables, all renewables. So there's two directors of in the Corp Dev. One is for gas.
Excuse me, sorry to interrupt.
Okay.
What is core? Can you? We're a public hearing as well, so I try to,
Okay.
have certain inside baseball terms shared or explained. So please proceed. Corp Dev.
Okay.
What does that mean?
Corporate development is the organization. Y'all got to talk with Miss Tara Fowler yesterday. She's the vice president over there, that organization. She has two individuals, two positions under her. One of them is Mr. Gertz. He focuses on the development of new projects from fossil generation, CTs, combined cycle, maybe some other new emerging technologies and stuff there that is associated with him. The other position was the position that Brad Morrison held, and he does all of the same duties, except he develops renewables. So that's wind and solar and hybrid systems, and he also is over the storage projects. So those two individuals. So either one of both of those corporate development functions, they build out projects to a certain point, go through the regulatory approval process, and once those are complete, they become viable projects going forward. They're handed over to the major projects group to build those projects as designed and bid into these RFPs. So I'm filling in for Mr. Morrison as he left the company, but I will be inheriting both the projects that Mr. Morrison's group developed on the renewables. That's what I'm testifying here today for. And I will be inheriting the projects for Mr. Gertz that we will be building those projects out as those projects as they get approved.
Thank you. And my next question is, what monies has Xcel Energy Services Incorporated already expended with these project development of the projects that you describe in your direct testimony?
Well, the goal of our organization is to minimize those expenditures as best we can until we get CPCN approval. We want to do everything we can in our to get the projects, keep them moving forward. But as you talked yesterday, for the CTs, we put down reservation dollars for the CTs. We've ordered CTs. Those are over in a capital services group. They're not assigned to the project yet, and they won't be until the project gets approval. The same thing happens on, say, wind turbines that are purchased or solar panels that are purchased. Those go over there in that organization, and those turbines, panels, wind turbines can be used for projects. They're designated to come for the projects that we're asking permission to build here in this proceed. But the event they're not built, or they get denied, or a modified version comes out, or whatever happens, we will find other places for those to go. We have multiple regions. We have all kinds of new generation build out in Colorado and Minnesota, and in Dakotas and Wisconsin, all that. So as of right now, the project itself, these projects themselves, we're trying to minimize those dollars as best we can. I can't tell you exactly right offhand what that number is yet, total for all the projects. But the goal is to keep our shareholders and our customers, keep those costs down as long as possible until we get the go ahead before we move forward.
Thank you. And you said that any equipment or material that Xcel Energy Services purchases and takes title to is held by Capital Services Group. Is that correct?
That's correct.
And can you explain for us where that fits in with respect to your group or Mr. Gertz's group, or even the team that is overseen by Ms. Fowler?
Yeah, they're a one of a sister organization that how they operate legally. I really can't. I probably can't answer the details of how they are legally there, but they're a sister organization, kind of a financing organization that we utilize to keep the operational companies like Southwestern Public Service. It gets very to keep the projects clean until ready to execute. So I don't know if I can go much farther than that in explaining exactly how
that's
it works.
fine.
Yeah.
Yes. Any information is helpful in clarifying how things are connected and related to one another. So I think those are all my questions, Mr. Lytle. I would just ask that we issue a bench request here for the same type of information that we asked for Mr. Gertz, Mr. Skinner, and that is what materials, capital goods have already been purchased. And I would just add that I don't believe that the bench request from Mr. Gertz has been sent to the parties yet, but we are concerned that the parties have as much time to review those answers as possible. So I just thank you again, Mr. Lytle, for your participation and professionalism. And I have no further questions, Hearing Examiner Hurst.
Can I
Thank
clarify?
Sure.
One thing?
Go ahead. Yes. Yes, of course.
Do you want the dollars that are associated with that are actually hitting the projects to date?
Tell me what you mean by hitting the projects.
Okay, there's the way the accounting works, there's project costs that go directly to the project. Those costs are ultimately everything that has been purchased, but those are the costs that we know are going to this project, whether it goes forward or not. Say, for instance, I don't know, we have to buy a piece of land.
Right.
That's going to hit the project. There are lots of things like transformers, switches, breakers, panels, combustion turbines, all those type of things that are currently in capital services, but aren't on the project itself. So I can give you the cost of that the projects are liable for at this point. I think that's what you're asking for. I just want to verify.
Yeah, I think what we're curious about is we'd like to know what expenditures have already been affected or charged to the company with respect to the proposed projects, both on the thermal side and on the renewable side. So that's the information that we're
Very well.
interested in understanding.
Okay, thank you so much.
So I think it is just exactly as you were clarifying it.
Okay, thank you.
Charge to the
hearing-
project. Thank you.
And hearing Examiner Schaefer to provide an update on the request that you made of Mr. Gertz, that is underway. We will have that filed by the end of the day with respect to the materials that have been procured with respect to, I believe that request was for the Gaines County project. We can also get you the same information with respect to the Tolk project, and then now the
Renewables.
the other projects, right, that
Right.
that Mr. Lytle covers. So we'll get the Gaines County project response filed today, since that was the prior request, and then we'll go ahead and put the rest of the materials together based on your request. I'll also offer that we intend to file an organizational chart that will show where SPS Capital Services, Excel Energy Inc., Excel Energy Services Inc., and other affiliated entities all sit. And that may be helpful clarity for the parties and your honors and the commissioners as well.
Yes, thank you so much, Mr. Skinner. My concern is just to make sure that all parties have an opportunity to review and raise any issues that they may see. So thank you again, and that's all I have, Hearing Examiner Hurst.
Thank you, Hearing Examiner Schaefer. Very nice segue into inquiry with regard to bench request 7, which you identified as being outstanding. And now, as I have taken down bench request 8, with regard to the renewables. I'm also seeing, since we're talking about outstanding, I don't believe we've seen answers on bench request 5 or 6. Either. So I also encourage SPS to provide the bench request information as soon as possible. Commissioner O'Connell already asked Mr. Lytle I believe it was a deferred question with regard to surplus solar bids into the market that had Mr. Lytle's name on them or on that question for me. So I don't have anything further this time, Mr. Lytle. Any redirect, Mr. Skinner, based upon the questions, the questions that Commissioner O'Connell had, or Hearing Examiner Schaefer?
No redirect, Your Honor. Thank you so much.
Very well. Last chance, any questions based upon the commissioners or the hearing examiner's questions from any party? Hearing none. Mr. Lytle, we appreciate your time, sir, and you're excused.
Thank you.
Thank you, Mr. Lytle.
I believe we have another witness.
Yes, SPS next calls to the stand Mr. Ryan Merrill.
Very well. Is Mr. Merrill going to be in the Zoom room?
I think Mr. Merrill will be joining separately.
There he is.
All right.
Good afternoon, Mr. Merrill. Actually, it's not afternoon. It's almost afternoon.
You're on mute, Mr. Merrill.
Morning.
Good morning. Welcome.
Thank you.
Mr. Lee, would you please swear the witness?
Mr. Merrill, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter not pending should be the truth, the whole truth, and nothing but the truth.
Yes.
Thank you, sir.
Thank you, Mr. Lee. Go ahead, Mr. Skinner.
Mr. Merrill, would you please state your full name for the record?
Sure. It's Ryan D. Merrill.
By whom are you employed and in what capacity?
I'm employed by Excel Energy Services as a tax consultant in the tax services department.
Do you have before you what has been marked as Exhibit SPS 28?
I do.
Can you identify that for the record, please?
Yes, it's the direct testimony of Ryan D. Merrill on behalf of Southwestern Public Service Company.
Was this document prepared by you or under your direct supervision and control?
Yes.
If I asked you the same questions today, would your answers be the same?
Yes.
And are those answers true and correct to the best of your knowledge?
Yes, they are.
Hearing examiner Hurst, with that, SPS moves for the admission of Exhibit SPS 28.
Mr. Merrill, did you have any attachments to your testimony?
I did not.
Very well. Is there any objection to what SPS has identified as SPS Exhibit 28, the direct testimony of Mr. Merrill as affirmed by him here today? Hearing no objection, SPS Exhibit 28 is admitted. Mr. Skinner?
Thank you, Madam Hearing Examiner. No further questions for Mr. Merrill at this time. He is available for questions from the parties.
Very well. Thank you.
Mm.
I believe that the only party that reserved time for cross-examination for Mr. Merrill was staff.
Yes,
And
ma'am.
I believe staff reserved 20 minutes for Mr. Merrill.
Yes, ma'am.
Go ahead, please.
Thank you. Good morning, Mr. Merrill. How are you?
I'm doing well. Thank you.
Could you go to page 6 of your testimony, please? On page 6, on line 1 to 2, you state that PTCs are available when the facility is placed into service. Is that correct?
Yes, I state that PTCs are available beginning on the date the generation facility is placed in service.
And on the same page, that would be page 6, lines 13 to 14, you say as much, you say the same thing about ITCs. Do I get that correctly?
Yes.
Could you go to page 5, please? Page
Okay.
5. Page 5 of your testimony, lines 15 to 17. You say that the base PTC rate is approximately 0.6 cents per kilowatt hour. Is that correct?
That is correct.
You also state that the full PTC rate of approximately 3 cents per kilowatt hour is only available if certain requirements are met. Is that correct?
Yes.
Could you tell us what these requirements are?
Sure. In order to qualify for the full PTC or the full ITC rate, a project needs to meet certain prevailing wage and apprenticeship requirements.
What is a prevailing wage?
So prevailing wage is basically a worker on one of these projects needs to be paid a prevailing wage as determined by the Department of Labor for the type of work that they're doing in the geographical area that they're doing the work.
Would you agree that if those requirements are not met, the project will not or does not qualify for full PTC rate?
If the prevailing wage or apprenticeship requirements are not met, that is true that it could jeopardize the qualification of the PTC or ITC. However, there are opportunities for the taxpayer to cure a deficiency with respect to the PWA requirements.
And how is that done? The curing?
So for a instance in which a worker was underpaid, the taxpayer could pay the difference between what the worker was actually paid and what they should have been paid.
To
And what
to whom does that payment affected?
to the worker.
If you go to page 6 of your testimony, we already said that, sorry, strike that. Is there anything else that a utility needs to do to get the full 30% of eligible costs?
Well, besides paying a prevailing wage,
Mhm.
they do need to make sure that certain apprenticeship requirements are met.
Okay. How does a utility demonstrate that it is in compliance with the prevailing wage and apprenticeship requirements?
They would demonstrate that, well, project managers monitor this, as well as our tech services department with the assistance of outside consultants. We monitor and record and document that the prevailing wage and apprenticeship requirements are met.
Timeline wise, is that happening during the course of construction or after or?
Yes, for the prevailing wage and apprenticeship requirements, prevailing wages need to be paid throughout the construction of the project until it is placed in service. And then after it's placed in service, prevailing wages need to be paid to any kind of alteration or repair. It doesn't apply to maintenance activities. And then the apprenticeship requirements don't apply after the project is placed in service.
I have a question about stackable bonuses.
Okay.
On page 10 of your testimony. Why not at page 10? Okay. You begin discussing stackable bonuses. What are those? Could you tell us what those are?
Sure. PTCs and ITCs are eligible for a couple of different enhancements. So these bonus credits are one, there's a domestic content bonus, and then there's also a energy community bonus. And both of these credits can be earned on the same project. And like you mentioned, they are stackable.
Which is?
Meaning that, for instance, for an ITC project that earns 30% for the full credit, a domestic content bonus would increase that to 10%. So you're at 40% ITC at this point. And then if you're going to qualify for the energy community bonus as well, that would be an additional 10%. So you would have, it would be a 50% bonus or 50% ITC.
But these bonuses are not automatic, correct?
Well, the bonuses,
Let me rephrase that. You have
yeah.
to qualify for the bonuses, correct?
That is correct.
Is it your position that SPS, as of today, knows with certainty that the proposed projects will qualify for these bonus credits?
Well, SPS could, not be certain at this point in time. These credits are subject to IRS review.
So it's not certain, correct?
Correct. However, SPS is, monitors and is very diligent about making sure that these credits are eligible for the projects are eligible for the credits and for the bonus credits.
But they also depend on future events that haven't occurred yet, correct?
The domestic, are we talking about the bonus credits?
Yes.
So the bonus credits are based on there could be situations where future events could impact that.
I have a question with regard to how the one big beautiful, okay, let's just call it OBBA because I can't remember the full name. It will affects these credits. In your testimony on page 14, lines through 16 to 20. Yes, starting at line 16. You explain that the OBBA terminates PTCs and ITCs for wind and solar facilities placed in service after December 31st, 2027. Am I reading that correctly?
That is correct.
Top of page 15, next page, you also talk about how the wind and solar facilities must begin construction before July 4th of 2026. Is that correct? If they want to be remain eligible, I mean.
Yeah, my testimony states that they must begin construction before July 4th, 2026 in order to maintain or be eligible to utilize the continuity safe harbor, meaning that they would have 4 years to be placed in service.
Could you explain safe harbor?
So a project, once you begin construction, a project, you would need to either document continuous efforts or continuous construction of that project throughout the project life cycle, or you can rely on the 4-year continuity safe harbor.
How does this affect wind and solar projects?
Could
Currently,
you
but,
rephrase the question?
yeah, sorry. In the current environment, how does the safe harbor benefit or don't benefit wind and solar projects?
So what the One Big Beautiful Bill Act did was accelerated the phase out of wind and solar projects. So what basically a wind and solar project needs to begin construction by July 4th, 2026 in order to be eligible to utilize the 4-year continuity safe harbor. If it begins construction after July 4th, 2026, it would need to be placed in service by December 31st, 2027.
On the same page, page 16, line 16, you discuss the physical work test. With regard to new projects. Could you Could you explain that a bit, please?
Yes. So in order to begin construction, a taxpayer would either, well, needs to meet the physical work test.
Which is what?
So it needs to show work of a physical work of a significant nature.
Okay. And it's that is a project-specific determination, correct?
That is correct.
So whether or not a project ultimately qualifies under that test is subject to IRS and Treasury interpretation, correct?
That is correct.
And even if a project satisfies the physical work test, it must also maintain a continuous program of construction to remain eligible. Is that correct?
A project to remain eligible would either need to meet the 4-year safe harbor requirement, or if it goes beyond that 4 years, it would need to meet be able to document and show continuous efforts and continuous construction.
You testified on page 17, and then continues on to page 18 that preliminary activities such as planning, permitting, financing, or site studies do not qualify as physical work of a significant nature, correct?
That's correct.
You also testify on page 15 through lines 9 to 13 that the OBBA includes foreign entities of concern restrictions, correct?
That is correct.
So under these provisions, projects may become ineligible for tax credits if they transact with or receive material assistance from prohibited foreign entities. Is that correct?
Projects that begin construction after 2025 would be subject to those rules, correct?
So whether a project ultimately complies with the foreign entities of concern restrictions depends on future regulatory guidance, does it not?
There is, well, the projects in the self-build projects in this portfolio, is my understanding, all began construction in 2025. Therefore, they would not be subject to these foreign entity of concern restrictions.
Isn't it true, though, that the IRS and the Treasury have not yet finalized the rules in implementing the FEOC provisions?
That is correct. We are awaiting guidance from the IRS and Treasury on the FIAC restrictions.
Let's go to page 19. Through lines 6 and 7, you state that SPS intends to pass the full value of any tax credits earned to customers through reduced rates. Am I reading that right?
That is correct.
You also state that SPS may be unable to use all tax credits in the year that they are generated due to insufficient tax liability. Is that correct?
That is correct.
Could you
However,
explain?
SPS has the option to transfer these credits to an unrelated party and monetize the credits earlier.
Could you explain that, please, that process?
Sure. So if SPS doesn't have sufficient tax liability to utilize the credits currently, it has the option of either carrying it back a year or carrying it forward 20 years. However, the Inflation Reduction Act had provisions in it to allow and introduce the concept of transferability, allowing companies to transfer these renewable energy tax credits to a third party.
Okay. Under the same topic, the next page on page 20, you also explain that recovering a return on a deferred tax asset would reduce the net value of tax credits passed to customers, correct?
That is correct. That's why SPS it would be more advantageous for customers for SPS to transfer the credits.
So whether it is decided that it is transferred, the credits are transferred or put into a DTA is has direct effect on the rate customers, correct?
Correct.
When you say you monetize the credits, does that require SPS to look for a buyer for the credits?
That is correct. The SPS would look to a unrelated party to sell the credits to.
Are the sorry, is the price paid for transfer tax credits less than the face value of the credits?
There are some transfer costs associated with selling these credits. However, it is my understanding that transferring the credits is much more advantageous to customers than if SPS were to hold on to these credits, and then which would necessitate SPS to create a DTA and earn on that DTA through customer rates.
On page 21 of your testimony, lines 11 to 13, you state that SPS anticipates that there will be a sufficient market to sell unused tax credits. Did I read that correctly?
Yes.
What is that anticipation based on?
Well, to date, SPS has sold all of its tax credits for its Hale and Sagamore wind farms. So 2023, 2024, 2025, all of those tax credits have been sold. Also, we believe that there'll be a significant appetite for credit sales based on the fact that in prior years, 2024, for example, there was 530 billion of corporate tax revenues and only 30 billion of credit transfers that year.
For whom?
Sorry.
Excuse me?
For whom? Who are those numbers for?
I'm talking about corporate taxpayers in general.
Okay. Thank you. Go ahead.
In order for these transfers or sales to happen, at a minimum, there needs to be a functioning market, right?
There would need to be other taxpayers with tax credit appetite.
Given the update in the climate for tax credits for renewables, I need to hold on. Yeah, given that, SPS cannot know with certainty whether these unused tax credits will be met with an appetite as healthy as anticipated, correct?
I'm sorry, could you repeat the question?
Given the current mood or general lack of, I guess, change in the treatment of tax credits based on renewables, does SPS think it's anticipated healthy appetite for a market for the resale or transfer of these credits? Don't you think it should don't you think it should reflect that change?
Excuse me, Ms. Lang, sorry to interrupt. That question was very confusing to me. Could you maybe just try again? Thank you.
You testified earlier, just a few minutes ago, that SPS anticipates a healthy or an appetite for these tax credits when SPS goes to the market and tries to sell them. Is that correct?
That is correct.
Don't you think perhaps that anticipation necessarily should be revised, considering the environment in which tax credits from renewables are being treated right now, at least in the federal regulatory environment?
I'm sorry, I don't understand the context of your question.
So you, when I asked you if SPS thinks that it will be able to transfer or monetize all the tax credits from the ITC and PTCs, you said yes, because we were able to do that in 2 previous years, correct? In 24 and 25 for Hale and Sagamore?
I mentioned that we were able to do it in the past in 23, 24, 25. We're currently selling 2026 credits. And then I also mentioned our basis for why we believe there will be tax credit appetite in the future.
Don't you think the appetite for tax credits in the future is going to be dampened by the federal regulatory environment currently?
I mean, I wouldn't be able to speculate on that.
You do agree with me that there is less tax credits based upon renewables is perhaps handled less favorably in the current environment than in the previous one, correct?
I don't agree.
Why not?
You're asking me if I believe that renewable energy tax credits are looked at less favorably in the current environment?
Yes.
I don't believe so. Could
Why
you
not?
state? I haven't seen any indication as to why that would be the case.
Okay, thank you so much. That's all I had.
Thank you, Ms. Lang. I do not believe that any other party reserved any time to ask questions of Mr. Merrill. I had a couple of questions just based on your recent answers, Mr. Merrill.
Okay.
In your testimony on page 21, you're responding to the question posed at line 6, has SPS had success in selling its existing credits? Your answer beginning on line 7 says yes. SPS has been able to sell all of the credits from Hale and Sagamore from 2023 through 2024 and is currently selling 2025 credits. That's your testimony, sir?
Yes, that was true at the time that this testimony is written. Since this testimony has been written, we have sold 2025 credits as well.
And I heard your testimony a few minutes ago to Ms. Lang that you're currently selling 2026 credits now, correct?
We will be selling 2026 credits this year, correct?
What type of response did SPS have? Well, I guess I want to ask, did SPS try to sell Hale and Sagamore credits prior to 2023?
So prior to 2023 was the first year the tax credits were available to sell.
Okay. And generally, can you tell me how can you quantify what type of monetary implication that sales of the credits have resulted in?
I'm sorry, could you rephrase that question?
Sure. Yeah. What kind of money has SPS garnered from the sales of the tax credits 2023, 24, and 25?
Are you asking with respect to
Hale and
the Hale and
Sagamore.
Sagamore?
Uh-huh.
Like, are you asking how many credits they produce on
No,
a
I
yearly
just wanted to
basis?
know money.
So,
What happened to the money from the sales? And how much was it?
So, I can give approximations. I don't have the specific details in front of me.
Okay.
But generally, Hale and Sagamore each, I believe, generate somewhere around 60 million of production tax credits annually.
Each?
Each, and that's subject to verification. I would need to go back and clarify that or confirm
Okay.
that.
So if they produce 60 million of PTCs each, say, let's just take one tax year, 2023, and SPS sold them, what did they sell them for?
Well, as I mentioned earlier, in my testimony, like there are transaction costs that are associated with these sales, and we make sure that they are within the rate that we're getting is within the market rate. However, I can't disclose the actual amount as it's trade secret.
Okay, can you tell me what happened after the reduction of the cost to sell? What happened to whatever amount that was?
So that amount, like the benefit that goes to customers through the fuel and purchase power cost adjustment clause, it also flows through there as a offset to that, offset to the benefit.
And do you have any numbers on what that was in 2023, 4, or 5?
I apologize. That's not in my testimony. I believe that I probably refer to Mr. Cunningham.
Okay. Okay, I think on page 19 of your testimony, you actually refer to Mr. Fisher. Well, no, that's tax credits in the revenue modeling, but okay, I'll try to find out from Mr. Cunningham. Again, just trying to compare what I think you referenced in your testimony as that the sales was more advantageous than SPS keeping them. and
Correct.
incurring uh,
Mm.
a cost on the deferred tax asset, right?
Right. Yeah, yeah, yes.
Okay, yeah, I'm just trying to quantify in my head the difference in that amount. I think
So
I understood.
So
Go ahead, sir.
in generally, if you look at the Crux Climate Market Report, I believe they state that the market generally is getting around 92.5 cents on the dollar for ITCs and 95 cents on the dollar for production tax credits.
Okay.
However, we can't disclose our exact amount.
Right.
Hmm.
Right. No, I get it. Do you believe that the ability to have these non-utilized tax credit for SPS is going to continue into the near future?
Are you asking if SPS will not have sufficient tax liability to use these tax credits? I
Yes.
would anticipate so that SPS would need to be able to transfer these tax credits.
For the foreseeable future?
I would expect so.
Very well. Thank you for those updates, sir. And that's all the questions I had. Hearing Examiner Schaefer, any questions for Mr. Merrill?
Yes, thank you, Hearing Examiner Hurst.
Go ahead.
Mr. Merrill, thank you so much again for being here with us and preparing your testimony. I wanted to ask you a little bit more about this dynamic of transferability. And as I've said before, we're a public hearing, and so have many people watching and participating that aren't necessarily experts in tax law or accounting. So I just want to ask sort of some foundational questions. If you can describe a bit this market of transferring and selling tax credits. Can you explain how that works exactly, how buyers meet sellers and how they work together to find an agreed upon price?
Sure. So originally, SPS or Xcel Energy developed its own market for selling these tax credits by reaching out to other third parties. Alternatively, there are brokers in this space that match.
Let me stop you. Sorry, Mr. Merrill. Sorry to interrupt. I try never
Sure.
to interrupt, but something I think foundational that is worth describing. What is the relationship between the SPS accrued tax credits and Xcel Energy Services?
So SPS earns these tax credits. Xcel Energy Services, we're a wholly owned subsidiary of Xcel Energy, who provide our services to SPS.
Okay, so you're a broker in a sense, an intra-corporate broker of SPS's tax credits.
I don't agree with the premise of that.
Okay, well,
so Xcel Energy owns both SPS and Xcel Energy Services. We are both wholly owned subsidiaries of Xcel Energy Inc.
right. And so before we go any further,
Mhm.
I'll just sort of explain my disposition here. And that is in many ways to be your student and to learn from your professional expertise and the particular matters at stake in the application. So feel free to approach me as somebody who is learning and to fill in the details as needed. But what I'm getting at as a prefatory matter or by way of preface is just to understand the relationship between the tax credits that are earned by SPS, which is a different company than Excel Energy Services. And I'm wondering if you can just explain that relationship that you started to detail a few moments ago.
So SPS earns these tax credits with the renewable energy projects that they own. And SPS is a wholly owned entity of Excel Energy Inc., which files a consolidated tax return every year. So these tax credits would roll up to Excel Energy Inc. When it files its tax return. And in this case, we're transferring these tax credits to a third party, so someone that's not affiliated with Excel Energy Inc.
And by we, you mean Excel Energy Services is transferring.
Well, SPS is transferring the tax credit. They're the ones who own the tax credit.
Okay, so also just to not to interrupt or belabor the conversation, but in these kinds of discussions, the use of pronouns like we or they can be a bit misleading because sometimes we're not sure if the we is SPS or the we is Excel Energy or the we is Excel Energy Services Incorporated. So as we proceed, the precision in actors is much appreciated.
Noted.
Okay, so please tell us how Excel Energy Services finds buyers of its tax credits.
We in tax services, which is a part of Excel Energy Services, markets these credits either directly to another third party, or we've utilized a broker service in the past on some credits in order to find a buyer for these credits.
So if I understand correctly, it's essentially whether Excel Energy Services Incorporated reaches out to a third party or a broker reaches out to a third party, that it is a bit of a private market. That is to say that the tax credits are not auctioned or there's no public exchange where these things are marketed or sold. Rather, it's a one person to person or entity to entity communication and offer. Is that correct?
I agree with that to date. That has been the case.
What are the disadvantages of such a marketing structure?
I don't know if I could speak to that.
Well, are there advantages or disadvantages to offering and ultimately selling tax credits through such a structure with respect to the price that is obtained by Excel Energy Services for its tax credits?
Well, as of to date, we monitor, like I stated, we monitor the market and make sure that we're getting a good rate for these tax credits. There's the Crux Climate Market Report that comes out, and they're they're really the ones that have their finger on the pulse of these tax credit sales and the discount rates in these contracts.
And why has the company, and in this case, I believe the company is, this is a bit, again, might require some clarification, but is it SPS then? Is it your testimony that SPS then would ultimately apply any tax credit revenue or profit from a sale to the fuel and purchase power contract adjustment clause?
Now that is correct. That SPS is gives 100% of the benefit of these tax credits to customers to the fuel and purchase power cost adjustment clause.
Net,
Is the
net
mechanism.
transaction costs.
The transaction costs also go through that same mechanism.
Why, and are you the one who makes the decision to apply those tax credit revenues to the fuel and purchase power contract adjustment clause in SPS?
I do not specifically. I would refer you to Mr. Cunningham as he discusses that in his direct testimony.
And from an accounting perspective, from a utility accounting perspective, what are the advantages or disadvantages of applying those tax credit revenues to a fuel and purchase power contract adjustment clause cost?
Again, I believe that's outside the scope of my testimony. I would defer you to Mr. Cunningham.
Mr. Merrill, you're a tax expert, is that correct?
I am. Yes, I work in the tax services department as a tax consultant, correct?
And you testified in a detailed fashion in your testimony about the application of tax credit revenues to the fuel and purchase power contract adjustment clause, didn't you?
In my testimony, I do refer to Mr. Cunningham's testimony with respect to how the fuel and purchase power cost adjustment clause mechanism.
So you have a professional and awareness, given your expertise as to why these tax credit revenues would be applied to the fuel and purchase power contract adjustment clause cost. Or is that incorrect?
I'm sorry, could you rephrase the question?
Given your years of experience, your expertise, the amount of detail and description provided in your testimony regarding the application of tax credit revenues to the fuel and purchase power contract adjustment clause costs, are you saying you have no idea as to the advantages or disadvantages of applying those revenues to those costs?
What I'm just saying that Mr. Cunningham discusses that more in detail in his testimony. However, it is more advantageous to flow it through to customers directly through that mechanism as opposed to SPS needing to create a DTA and recovering through rates.
And what discussions have you had with your team or your colleagues, either at Xcel Energy Services Incorporated or at SPS, with respect to the manner in which such tax credits are impacted, or the revenue of such tax credits are impacted by a multi-jurisdictional utility?
Again, could you rephrase the
Sure.
question?
Is SPS a multi-jurisdictional utility?
Yes, SPS has jurisdictions in New Mexico, Texas.
So the revenue from these tax credits, from the sale of any tax credits, how do you account for the customer benefits across a multi-jurisdictional or on a multi-jurisdictional basis?
Again, that is out of the scope of my testimony. I would need to refer you to Mr. Cunningham.
Have you had any discussions in how many years have you been working at Excel Energy Services?
So I have over 15 years of experience in public accounting and utility uh, tax consulting. I started work with Excel Energy Services back in 2012.
You cannot tell us anything about how revenues from sales of tax credits are allocated in a multi-jurisdictional fashion?
I apologize. That's out of the scope of my testimony.
Okay, well, it may be out of the scope of your testimony, but I was really more asking with respect to your experience and expertise. But Mr. Merrill, thank you so much for your professionalism and contribution to our proceeding. I have no other questions, Hearing Examiner Hurst.
Thank you, Hearing Examiner Schaefer. Mr. Skinner, any redirect?
I do not, Madam Hearing Examiner, no.
Very well. Anyone have questions based on Hearing Examiner Schaefer or my questions? No, hearing none. Thank you very much, Mr. Merrill, for your time. Appreciate it. Your excuse, sir.
Right. Thank you, Madam Hearing Examiner.
Thank
Mr.
you.
Merrill.
Very well. I think we have reached the time perhaps for our luncheon recess. I have 12:30, so let's come back at 1:15 and we will resume the examination, cross-examination of SPS witnesses. Please remember that the YouTube will still be on. Ms. Amer?
Yes, Madam Hearing Examiner, I know we talked about the order of witnesses last Friday, and I just want to confirm that next is Mr. Trowbridge.
I believe the next witness is Mr. Fisher.
And then after Mr. Fisher,
Is Mr. or Trowbridge?
and then is it Mr. Cunningham?
I'll have to check with SPS. Mr. Skinner, do you know who's after Mr. Trowbridge? Is it Mr. Goodenough?
I believe that may be correct, Madam Hearing Examiner. I think Ms. Hardy has the next witnesses, so I'll defer to her.
Okay, Ms. Hardy.
That is correct, Madam Examiner.
Okay, so we have Fisher. Is it Trow or Tro?
Trowbridge.
Trowbridge, and then Mr. Goodenough?
Yes, that's correct.
Okay, very well. Answer your question, Ms. Amer?
Yes, thank you.
Okay, very well. We'll resume at 1:15. Thank you.
Hey David, how you doing?
Fine, Miss Sir. How are you?
Good. It's good to see you.
Good to see you too. Are you carrying the mantle for Sierra Club now?
Just today, just this case.
Well, you want me to talk to him, see if I can get you some business?
Really? No,
I'm teasing.
I don't think so, but thanks.
Mr. Lee,
Judge?
are we good?
Yes.
Awesome. Very well. Let's go back on the record. We're back from our lunch and recess. And I believe Mr. Skinner deferred to you, Miss Hardy?
That's correct, Madam Examiner. I'm next.
Okay, very well. You have a witness.
I do. SPS's next witness is Mr. Richard Fisher.
I just admitted him, Mr. Fisher.
Hello, can you hear me all right?
I can hear you just fine. Welcome.
Thank you.
Mr. Lee, would you please swear the witness?
Mr. Fisher, would you raise your right hand, please? You solemnly swear the testimony you're about to give in the matter now pending should be the truth, the whole truth, nothing but the truth?
I do.
Thank you, sir.
Thank you, Mr. Lee. Go ahead, Miss Hardy.
Thank you. Mr. Fisher, can you please state your name for the record?
Richard Fisher.
By whom are you employed and in what capacity?
I'm employed by Excel Energy Services as part of Excel Energy Inc., and I'm the Director of Revenue Analysis.
Do you have in front of you a document that is marked as SPS Exhibit 31?
I do.
Can you please identify that document?
It is my direct testimony on behalf of Southwestern Public Service Company.
Was your direct testimony prepared by you or under your direct supervision and control?
Yes,
Are there attachments to your direct testimony?
there are.
And are those attachments, were they prepared by you or under your direct supervision and control?
Yes,
Do you have any corrections to your direct testimony?
yes, I have a couple.
Can you please identify those?
On page 8, line 8, strike Oneida Chew Solar and as well as on that same line where it says RPS 30 projects, it should be singular project. On page 9, line 6, the word 8 should be replaced with 7. And finally, on page 11, line 18, towards the end of that line, the word 2, the number 2 should be struck.
Thank you. With those corrections, is your testimony true and correct to the best of your knowledge?
Yes,
And if you were asked the questions in your direct testimony today, would your answers be the same?
they would.
Madam Examiner, I move the admission of SPS Exhibit 31.
Any objection to what has been identified as SPS Exhibit 31? Mr. Fisher's direct testimony as corrected and affirmed by him here today. Hearing no objection, SPS Exhibit 31 will be admitted. Ms. Hardy?
Thank you. I have no further questions for Mr. Fisher. He's available for cross-examination.
Very well. I believe that our first cross-examiner who reserved time for Mr. Fisher is LES.
Your Honor, the NMLCG had crossed for Mr. Fisher as well.
Okay. My sheet's getting pretty marked up at this point. You did. You reserved 15 minutes. Mr. Stoffel,
That's correct.
go ahead, sir.
Thank you. Good afternoon, Mr. Fisher.
Good afternoon.
For the record, I'm Nick Stoffel, one of the attorneys representing the NMLCG in this proceeding. You present the forecasted revenue requirement for the self-build projects, correct?
That's correct.
And the forecasted revenue requirement includes modeled impacts of the value and costs for federal tax credits for eligible projects, right?
That is correct.
And those tax credits lower the cost of new renewable and battery energy storage projects, right?
Yes,
Now, production tax credits for wind and solar resources are based on the energy production from those eligible facilities, correct?
that is correct.
What was the source of the forecasted renewable generation for the proposed self-build projects that drove the modeled tax benefits?
I use the same projected generation outputs that were used in the bid modeling.
And in the forecasted revenue requirement, investment tax credits, net of transfer costs, are amortized over 5 years. Is that right?
That is how it is modeled, correct?
And production tax credits, net of transfer costs, are credited to customers as generated, right?
Correct.
And so then the model as generated was the output used from the bid modeling. Is that right?
Yes,
And then the forecasted revenue requirement you sponsor is based on the jurisdictional allocation that the company proposed in this proceeding, correct?
I would frame it as we didn't propose the jurisdictional allocator, but rather we projected a jurisdictional allocator that was used for the forecasted revenue requirements.
And the jurisdictional allocation approach, the methodology is the same that was assumed for modeling the revenue requirement is the same that the company has proposed for commission approval in this case, right?
That is correct.
The assumed jurisdictional allocation used in the revenue requirement forecast does not reduce the New Mexico allocation of capacity costs to reflect the capacity value of any direct assigned resources, right?
I don't know if I'd be able to answer that question. I didn't derive the allocation percentages. That would be Mr. Trowbridge.
Looking at attachment RF1 to your direct testimony, beginning on page 42 of the PDF, that's page 1 of 18 of attachment RJF1. Let me know when you're there.
Sorry, what page again?
It is page 1 of attachment RJF1.
1 second. I am there.
So this attachment shows the forecasted revenue requirement for all of the proposed self-build projects, including the RPS 30 resource, correct?
That is correct.
And as we can see, the revenue requirement increases from 2027 through 2030, right?
Yes,
And that's shown on line 1.
that is correct.
And 2030 is the year with the highest revenue requirement without considering tax credits, correct?
Yes.
Now looking at page 2.
Give me 1 second. I'm there.
So there we can see the forecasted benefits from the production tax credits and the amortization of the investment tax credit, right?
That is correct.
And so during that period, would you agree that the benefit, the discount from the tax credits is somewhere in the neighborhood of 25 to 40%, depending on the year?
I'm sorry, percent of what?
The percent of the total revenue requirement, essentially how big of a discount from the total revenue requirement on line 1 do the tax credits provide when they are available?
Yeah, that range sounds appropriate with unable to do the precise math in my head.
That ballpark though. So if we skip ahead to page 3 of 18.
I'm there.
There we see the increase in revenue requirement once the tax credits drop off, correct?
You're talking between 2038 and 2039?
Correct.
Yes, I see that.
And the revenue requirement in 2040, when the tax credits drop off, is higher than the forecasted net revenue requirement in 2030 and 2031, right?
That is correct.
Now, you did not provide a forecasted revenue requirement where the gains in Tolk resources are depreciated so they're fully recovered by 2045, correct?
Correct.
And you also did not provide a forecasted revenue requirement assuming direct assignment of any of the proposed non-RPS renewable generation facilities and battery storage systems, correct?
That is correct.
Thank you, Mr. Fisher. I have no further questions.
Thank you.
Thank you, Mr. Stoffel. Okay, I think as I previously indicated, LES reserved 15 minutes for Mr. Fisher.
Yes, ma'am. This is Joan Drake for LES. We don't have any questions for this witness. If we could add our time from this witness to our cross-exam for Mr. Goodenough, we would appreciate that.
Okay,
Thank you.
thank you. I think the next party to reserve time, Ms. Lynch, Mr. DeSalen, CCAE reserved 15 minutes.
Correct. CCAE has no questions.
Okay. And you reserved 10 minutes for Prosperity Works, Ms. Lynch?
Correct. And we also do not have any questions for this witness.
Okay. Ms. Sir, I believe Sierra Club reserved 5 minutes.
Yes, I would like to just reserve that to the bank. I have no questions for this witness, if I may do so.
And I believe staff reserved 15 minutes. Ms. Amer, Ms. Lang,
Yes, Madam Hearing Examiner.
go ahead, please.
Thank you. Hello, Mr. Fisher. My name is Judy Amer, and I am an attorney for the New Mexico Public Regulation Commission's Utility Division.
Good afternoon.
Good afternoon. Your revenue requirement model treats federal tax credits as direct reductions to costs, correct? I'm referring to page 25, line 3.
That is correct.
And those reductions will lower the projected revenue requirement that you presented to the commission. Is that correct?
That is correct.
And isn't it true that you calculated the direct reduction based on receiving the full value of the ITCs and the PTCs?
Perhaps you can clarify what you mean by full value?
Whatever, well, when you did the calculation of the direct reduction, what did you base it upon?
Yeah, I based it on the PTC rates and the ITC percentage presented in the table right above the testimony line you referenced, RJF 5. And that was the assumption I made in the model, along with transfer costs associated with those tax credits.
And is that based upon the IRS direction at this time?
Correct.
And is it also based upon the projects being completed at a specific time to get that value?
I can't speak. I didn't evaluate the eligibility for the PTCs and the projects. That would have been Mr. Merrill that provided these tax credit rates to me, but that is my understanding.
Do you know, and if you don't, you can just say, do you know when the projects have to be completed to get the value that you used?
I honestly can't speak to that. I don't know if it has to do with project completion or project start as far as eligibility for the tax credits.
And do you know how value will be lost over time if projects aren't either completed or started at the right time?
No, I can't speak to that.
Okay. But if some value were lost, would that increase the costs in all of your tables?
If the rates I used in the modeling are less in actuality than what was modeled, then yes, all else being equal, the overall cost to customers would be greater.
Okay. Do you know about bonus amounts?
I know the bonus amounts we included in the assumptions.
But are there certain requirements to receive them?
That's my understanding.
Um, your model also assumes that SPS is able to transfer those credits on an ongoing basis.
We assume transferability of both the PTCs and ITCs and the forecasted revenue requirements.
Do you know the total nameplate capacities and estimated costs for the solar and wind projects?
I do not know the nameplate capacities off the top of my head. I believe there's a table in my testimony with the overall construction costs and APC.
Okay. Can you look at your direct RJF3?
I'm sorry, are you referring to the table RJF3?
Yes, the direct table RJF3.
I'm there.
Okay. What is the total AFUDC?
Across all the projects?
Yes.
I don't list a total on this table. I don't know the total offhand, but we do list it by project in this table.
Okay. What is the AFUDC total for the proposed solar and wind projects?
Again, I can't do the math quickly in my head, but we show it for each of the wind and solar projects individually on this table.
Would 324,454,454, would that be about correct?
That doesn't sound right. I'm looking at Lariat Wind and Yellow House Wind, and 285 million and 75 million already gets you over 350. So we're looking closer to 400 million when you add in standing loan solar.
Okay. Do you realize that if the application is approved, then there would be an assumption that that amount of AFUDC was reasonable?
That's my understanding of the rules.
And so when the company would earn a rate of return and base rates on the AFUDC, would there be any incentive to reduce that total AFUDC?
Well, AFUDC is largely a function based off a FERC formulaic calculation, and then the timing of the construction and the construction spending. So I'm trying to understand your question on how we can manipulate the AFUDC amount and the incentive you're referring to.
Well, isn't it true that the AFUDC is calculated upon debt and equity rates, and those could change?
That is correct.
Do you know if SPS is anticipating a credit downgrade?
I know we've been analyzing it and following Mr. Asmus's testimony that there were concerns around cash flow and potential credit downgrades.
Do you know what might be causing that concern?
I can only
Objection.
Ms. Hardy?
I think that is outside the scope of Mr. Fisher's testimony. He doesn't address credit ratings or downgrades.
I'm just asking what he knows about. He just testified that he knew there was discussions and concerns about it, so I was just asking what he knew about it.
Ms. Hardy?
Same objection. I suppose he
he
can
actually-
answer it if he knows, but
Yeah, and he actually, on page 16 of his testimony, at line 2, the question posed says, did SPS include the impacts of increased cost of debt financing due to a potential credit downgrade in his AFUDC calculation? So I'm going to overrule the objection. Answer if you know, sir.
I'm sorry, can you repeat the question?
Yes, I can. Mr. Fisher, you testified that you knew that SPS was concerned about a credit downgrade. What is your knowledge about those concerns of a credit downgrade?
Yeah, I can only speak generally that, there's a concern around cash flow and servicing debt and the credit metrics and how they rate companies and assessing credit metrics. And there was a concern that we would surpass those thresholds that the credit rating agencies would uh, assess SPS on and that condition, that financial condition.
Thank you. I have no further questions. I don't know, how much time was reserved? 15 minutes? How much do I have left?
You used 10.
Could I credit the 5 minutes to either Mr. Cunningham or Mr. Trowbridge?
Okay.
Thank you.
Thank you. Hearing examiner Schaefer, do you have any questions for this witness?
Yes, I do have a few questions. Thank you, Hearing Examiner Hurst.
Go
Mr.
ahead,
Fisher,
sir.
thank you for taking the time to be with us. I'm wondering if we could look at one of a section of your testimony. This is on page 25, and the question begins on line 2. And I'll give you a minute to get situated.
I'm there.
Great. So we have been discussing and trying to understand from a broad and also particular level these tax credits, how they're sold and how they're valued, and also how they're accounted for within the utilities, revenue calculations and credited to customers. So also, it's important to remember that some of these questions we ask are for the general edification of all of the public that's participating in the hearing, and not just the experts with these issues. So if we can look at that answer, well, let's look at the question first. How are those credits reflected in your revenue requirement modeling? And I wonder if we can just start there, and if you can tell us about what is the model and how does it work?
Yeah, so my overall revenue model calculates the revenue requirement of the facilities based off of their construction costs, so the plant and service, depreciation, and other rate-based items, including accumulated deferred income taxes. Also includes income tax expense as well, operational and maintenance expenses, property tax, insurance. So all the different cost components mentioned throughout my testimony to arrive at an overall revenue requirement. The tax credits are layered in as generated. For PTCs, they're layered in as a credit
Well,
as
let's
generated.
just,
Yep.
sorry to interrupt, but let's just go sort of piece by piece. So the model is your or maybe the company's, Xcel Energy Services, own revenue requirement model. It's not a third-party proprietary software. It's a revenue requirement model that you and your team, or that you and your colleagues fashion internally. Is that correct?
That is correct, consistent with revenue requirement calculations in New Mexico.
Yes, great. And I'll just let you know that the reason I'm asking is because there's been many models mentioned in the testimony from many different witnesses. So I think some of the benefit that hearing examiners can provide is clarifying sort of common words or common phrases that are used, but in different ways. Okay, so then the next question I have is, if you can look at that second sentence, and I think you were about to get to this. You say for ITCs, this is investment tax credits, the value net of transfer costs is amortized over 5 years, grossed up for taxes, and credited annually to customers. Did I read that correctly?
That is correct.
And my first question is with respect to transfer costs. Who incurs the transfer costs? What entity incurs the transfer costs?
As far as from an Excel Energy group of companies, I'm trying to find the context of your question.
Well, actually, that's what I'm hoping to do here with your answer is try to glean the context because your sentence says the value is amortized, but then there's a qualification to the value that says net of transfer costs. So, for whom do those transfer costs arise?
Yeah, so the transfer costs arise usually as a discount to the tax credit as it's being sold. That's the incentive for an off-taker or a buyer of the tax credit to utilize is they'll get an incremental value on the total tax credit. As Mr. Merrill testified, there could be some other administrative or transaction fees if there's a broker involved or whatnot, but a large portion of the cost is really a discount to the nominal value of the tax credit.
Okay, so if I'm understanding correctly, transfer costs include not only administrative or processing fees, but also includes the discount of the tax credit in order to incentivize its sale.
That is correct.
Okay. And then you state in your sentence that is amortized over 5 years. Can you explain that, with respect to the revenue requirement and what you mean exactly by that, how the value is amortized over 5 years?
Yeah, so maybe I'll back up just a step. The investment tax credit associated with the batteries is essentially earned upon in servicing of the facility. So it's a raw percentage of the construction costs, and so that's earned, when the unit goes into service. And so I used a 5-year amortization consistent with previous proposals to amortize the value to customers, and so we proposed 5 years for the amortization of that value net of transfer costs.
Great. And by the way, if it's helpful for us, we can definitely use pro forma figures like, $1,000 or
Okay.
$1 million or something just for the sake of understanding that. So if I understand correctly, so value net of transfer costs, if that would yield a value of $1 million, the proposal is to amortize that $1 million over 5 years. Is that correct?
That is correct.
200,000 a year. Okay. Excellent. And then tell me this, what this means, grossed up for taxes. How does that impact the value of the ITC?
Well, we gross it up for taxes because the effect that revenue has on the company relative to our tax position. So when we gross up the value, it actually creates greater value for the customers that flows through. So I'm going to use round numbers as an example here. For in your $1 million example, if we gross it up for taxes, that might be $1,200,000 that ultimately flow back. Because ultimately what happens is we are lowering our revenue to customers. And so the revenue we get in the door from a tax position is lower. And so we have that benefit of the revenue credit. And so we gross up that revenue credit for taxes to basically reflect the tax affected position.
Okay, that's very helpful. And I think those are the exact same questions I had for you with respect to the production tax credit, because the ITC and the PTC sentences are almost identical in structure, except for the subject matter. Now, can you tell us a little bit about the decision to apply the value of these tax credits through a fuel and purchase power contract adjustment clause, as opposed to some other manner to credit customers?
Sure. The PTCs are proposed to flow through the FPPCAC, or the Fuel and Purchase Power Cost Adjustment Clause. And that for PTCs allow us to flow those benefits through immediately upon generation. So as we generate the credits, the customers get the immediate benefit of that credit through fuel.
Okay, thank you for that. And why maybe is that the most beneficial manner in your view to credit the customer?
Well, I think there's a combination, and I'll answer your question that in two parts. One is that we have precedents with the Hale and Sagamore Wind Farm of crediting PTCs through fuel. The recent stipulation in our last FPPCAC to do that for the solar facilities coming online this year and next year. And so part of that is precedent. Part is that advantageous result of flowing through the tax credits immediately upon generation and dollar for dollar. So as opposed to the other disadvantage of not doing that in a rate case is a rate case sets the amount and then your base rates effectively reflect that amount in continuity until your next rate case. So I think there's two benefits. One is the immediate credit to customers, and then two is their credit the full amount, no more, no less.
Thank you. And by the way, everybody, hearing examiner Hurst just lost the feed to our hearing. So I think we might want to just go into a brief recess and let me call her and see where she is with oh, she says she's back. So sometimes intention is more important than action. And it looks like she's getting back on. So we'll just give her a minute here to get reconnected.
Thank you, hearing examiner Schaefer. I don't know. Perhaps my computer froze.
Well, it's not the only thing that's freezing these days.
Exactly.
Hearing examiner Hurst, I was just going to continue with Mr. Fisher with my final question, or maybe my
Great.
final few questions. Mr. Fisher, thank you again for taking the time to walk all of us through that. I wanted just to ask you about how this application impacts or relates to the rate case, the SPS rate case that was filed recently. And if you, again, could sort of walk us through that, and that would be very helpful.
Yeah, I can speak to my knowledge on it, and if we have any gaps, we can explore that. So in the rate case, we have a couple things going on relative to this filing. We have the Plant X BESS is included in the FTY we recently filed. It's in service date is within our test year, and that's within this application. So the ITC is reflected for that. That's a battery energy storage system. And so the ITC is included in that, including a proposed amortization of 5 years, as well as a deferred tax balance and a return on that deferred tax balance for that facility. The other projects are in this application are not in the rate case. Their in-service dates fall outside of the FTY at this point. I'm sorry, I can't hear you, Commissioner Schaefer.
Sorry, FTY means future test year. FTY means future test year.
Yes, that is correct. FTY means future test year.
And so then the commission could expect that many of the costs associated with the other projects in this application would come to bear on SPS's next rate case.
Yes, that's what it's looking like at this time.
Great. Thank you, Mr. Fisher. Hearing examiner Hurst, I don't have any other questions at the moment.
Very well. Thank you, sir. In response to bench request 1-3, which you're the proposed sponsor of, Mr. Fisher.
Yes.
You also included in the revenue requirement for the rate case the 6 LTPPAs proposed in case number 25-00086 85-UT?
That is correct. Those are the long-term purchase capacity agreements, and those, I believe, are in a separate CCN application or approval application.
But as far as your response to the bench request which was, are any of the self-build projects in this case the long-term PPAs in 2085 or any upcoming proposed build to transfer projects for which the SPS will seek approval included in the revenue requirement in the rate case? Their answer was the Plant X battery energy storage system and the 6 LTPPAs, correct?
That is correct.
Additionally, with regard to bench request 1-2, which was please provide the jurisdictional allocation percentages for the generation costs included in this proceeding. You're also a sponsor to that answer, correct?
That is correct.
You and Mr. Trowbridge?
Yes.
And it looks like your part of it says attachment RJF-1 to your direct testimony provides the total revenue requirement for the self-build projects as allocated to the New Mexico retail customers and includes an offset for federal tax credits, correct?
That is correct.
Did you remove Oneida 2 solar project from that attachment?
Yes, we did in the errata that we removed Oneida in.
The errata to your testimony?
Correct.
And then finally, with regard to bench request 1-4, which says, please identify the benefits that Sandy Loam solar project, which SPS proposes to directly assign to New Mexico retail customers, will provide to SPS's New Mexico retail customers. And you're one of the respondents to that bench request also, correct?
Correct.
And it says the offset for the benefits of PTCs to the revenue requirement is included in the portfolio summary review requirement provided as RJF-1 and included in the specific revenue requirement provided as RJF-9 to your testimony. Correct, sir?
That is correct.
And then I just wanted to look a minute. Page 14 of your direct testimony. The question posed at line 4, did SPS add any other expenditures to the self-build project capital construction costs? You begin your answer at line 6. You say SPS did not add any new project expenditures other than the generation interconnection costs discussed previously. However, SPS owns the land for the Gaines County Thermal Facility recorded as land held for future use at, is that $4,167,109?
That is correct.
How much acreage is that?
I honestly don't know. Hearing Examiner Hurst off the top of my head. I may have heard it at one point, but I don't know that answer.
It's located in Southwest Texas.
That's my understanding, but it's beyond my expertise, I'm afraid to say.
Do you know what distinguishing or valuable characteristics that this particular piece of property has that might describe or justify its $4,167,109 price tag?
I do not know the answer to that.
Well, including it, well, let me ask this. Where is it recorded as land held for future use?
So there's FERC accounting that allows for plant held for future use and land held for future use. So it's sitting in a special account designated as that.
And who gets to name what it's worth?
Well, typically the cost that we paid is what's on our books, not the value. And so I don't know, I wasn't involved in the purchase of this land, and I don't know what evaluation or appraisal went in or assessment on the purchase of it. But the cost of what we paid would be what we accounted for on our books.
Do you know whether or not there currently is any other SPS generation or other type of plant on that property?
I do not know the answer to that. I was under the impression and that this was for the Gaines County Thermal Facility.
So SPS went out and bought it in anticipation to build a generation plant there?
I don't know the answer to that here in Examiner Hurst.
And have you reviewed the testimony and or other specifics with regard to SPS's application in this case?
I've read most of the testimony in a cursory fashion. Some of it may have been when we first made the application and shortly after.
Well, Mr. Stoffel actually already asked you my question. But I'd like to know why you gave the answer that you did.
Okay.
When we're looking at page 17 of your testimony, and the question posed, how did SPS calculate depreciation expense for these facilities, posed at line 1, and then at line 2 you start giving your answer. And then I'm interested in the line 6 and 7. And it says for the TSG, you wanted to define that for me, assets?
Yeah, TSG stands for Transmission Serving Generation.
Okay. And you talk about using a composite depreciation rate based on commission approved depreciation rate for transmission FERC accounts. And you go on to page 18.
I'm with you.
Year-end 2024 asset balances. So just looking at your answer for that page, and then and how SPS values this, Mr. Stoffel, I think, asked you whether or not you performed any type of depreciation analysis for gains that would have it come in at, I guess, be fully depreciated by 2045? Do you remember that question?
I do remember that question.
And your answer was no, correct?
Yes, we did not provide revenue requirement with an end of life of end of year 2044.
And my answer or my question is why not? If you're familiar with the rest of the application and knowing the Renewable Energy Act or being familiar with Renewable Energy Act requirements that take place in 2045, don't you think that it might have been helpful just to provide that depreciation analysis, having a shorter useful life in this case?
What I'll say is I'm not really familiar with the Renewable Energy Act, aside from what I've learned through these hearings, to be honest with you. When I prepared the original revenue requirements, it was under the understanding that these facilities would operate over the useful lives provided by the bidders. And so that's what I modeled in my revenue requirement scenarios.
But you've come to find out in your participation and reading and watching in this case that 2045 wasn't just picked out of the air, but that it has a definitive meaning, at least now, as the renewable requirements in Energy Transition Act requirements are currently set forth in New Mexico, right?
That's my understanding, correct?
So you didn't think maybe that we might want to see what that would be if you had a shorter life, or what that might look like if you if you only allocated it up to 44 and then had to have some alternative scenario?
I largely follow the recommendations of what we want to do in response to discovery requests, and obviously from the hearing examiners here. The models are fairly complex, so I'll be honest, when we run models for different scenarios, it does take time and complexity. I know that Mr. Gable did provide a comparison of the levelized cost of capacity with the different life projections in his testimony. But we did not provide that in the course of this application.
Yeah, I think I'm still waiting for that. I think I'm still waiting for Venture Quest 5 as the levelized cost of capacity. I don't think I have that yet. Just like I'm waiting for Venture Quest 6, the revenues from by resource type. But anyway, no, I hear what you're saying. From our perspective, might have been helpful for us.
I understand.
When you do this forecasting and you use this 12CP dash PROD, do you use that to forecast in all your jurisdictions?
That is a common allocation, demand allocator that we use for our capital costs that are generation related in both Texas and New Mexico.
Very well, Mr. Fisher. That's all the that I had for you. Ms. Hardy? Any redirect?
I do not have any redirect.
Very well. Any questions for Mr. Fisher based upon hearing examiner Schaefer's questions? Or my questions? Hearing none. Mr. Fisher, thank you for your time, sir. You're excused.
Thank you.
Thank you, Mr. Fisher.
Thank you.
Ms. Hardy, you have another witness.
I do. And Madam Examiner, I did want to let you know that I believe the information you were just referencing in the bench request is included in our response to the third bench request, and that should be uploaded.
Okay, I only
believe
have
it
one and two in front of
Okay.
me.
Okay.
When did 3 get?
I'm
When
not
did
sure
3 go to the Dropbox?
I'm not sure exactly when it was uploaded, but it should be there.
Okay, let's see if I can find it.
If it's not there yet, it's in progress.
Okay, I don't see it yet.
Okay. Then it should be there shortly.
Very well. Okay, would you like to, we need Mr. Trowbridge
Yes.
is your next witness. I just admitted him.
Thank you. And his last name is pronounced Trowbridge. I was wrong earlier and I know how to pronounce it, so I apologize. It must be hearing fatigue.
Ah, no, it's Monday. No, it's not Friday.
That could be it. Yeah.
Very
Could
well.
be Monday.
Mr. Trowbridge.
Yes.
Good afternoon. Welcome.
Thank you.
Mr. Lee, would you like to swear in the witness, please?
Mr. Trowbridge, would you please raise your right hand? You solemnly swear the testimony you're about to give, no matter not pending, should be the truth, the whole truth, and nothing but the truth.
I do.
Thank you, sir.
Thank you, Mr. Lee. Go ahead, Ms. Hardy.
Thank you. Mr. Trowbridge, can you please state your name for the record?
My name is Alexander Gage Trowbridge.
By whom are you employed and in what capacity?
I'm employed by Excel Energy Services, and I am the SPS Director of Regulatory Pricing and Analysis.
Do you have a document in front of you that's marked as SPS Exhibit 32?
I do.
What is that document, please?
That is my direct testimony in this case and attachments.
And was your direct testimony, along with the associated attachments, prepared by you or under your direct supervision and control?
It was.
And is your direct testimony true and correct to the best of your knowledge?
It is.
If you were asked the questions in your direct testimony today, would your answers be the same?
They would be.
Madam Examiner, I move the admission of SPS Exhibit 32.
I also have Exhibit 33.
Hang on just a second. Did you have any attachments to SPS Exhibit 32?
Yes, I do. I have 6 attachments.
Okay, and were they prepared by you or under your direction and control?
Yes, they were.
Okay. Do you have any corrections, additions, or deletions?
The only
to 32.
Yeah, to 32. It states that on page 1, it states that I am a manager of pricing and planning, and I've been promoted to
Sorry, sir, you're a manager of pricing and
pricing and planning.
Okay, and now you are king of pricing?
I am director of
Director, okay.
regulatory pricing and analysis.
Congratulations.
Thank you.
Any objection to what has been identified as SPS Exhibit 32? Mr. Trowbridge's direct testimony as corrected and affirmed by him here today. Hearing no objection, SPS Exhibit 32 is admitted. Ms. Hardy.
Thank you. Mr. Trowbridge, do you have a document in front of you that's marked as SPS Exhibit 33?
I do.
What is that document, please?
That is my rebuttal testimony in this case.
Was that testimony prepared by you or under your direct supervision and control?
It was.
Are there any attachments?
There are no attachments to that testimony.
Is your rebuttal testimony true and correct to the best of your knowledge?
It is.
If you were asked the questions in your rebuttal testimony today, would your answers be the same?
They would be.
Madam Examiner, I move the admission of SPS Exhibit 33.
Any objection to what's been identified as SPS Exhibit 33, the rebuttal testimony of Mr. Trowbridge as affirmed by him here today? Hearing no objection, SPS Exhibit 33 is admitted. Ms. Hardy.
Thank you. I have no further questions. Mr. Trowbridge is available for cross-examination.
Very well. I believe that Mr. Stoffel, large customer group, reserved 20 minutes for Mr. Trowbridge.
That's correct.
Go ahead, sir.
Thank you. Good afternoon, Mr. Trowbridge.
Good afternoon, Mr. Stoffel.
Thank you. For the record, I'm Nick Stoffel, one of the attorneys representing the NMLCG in this proceeding. First, Mr. Trowbridge, you testify that 2030 is the first year that all of the proposed self-build projects are in operation for the entire year, and 2030 is the year in the forecast period with the largest revenue requirement. Do you recall that?
Yes.
And when you're describing 2030 as the year with the largest revenue requirement, that excludes any value from the tax credits, correct?
The largest net revenue requirement is what's presented in 2030. So it includes the offset associated with the production tax credits.
So to be clear, in 2030, the revenue requirement is the highest, excluding the tax credits, right?
Including the benefit associated with the tax credits.
Well, as we went through with Mr. Fisher earlier, actually 2040 is the year with the highest revenue requirement for customers when considering the tax credit benefits. Are you aware of that?
No, I don't. I'm not familiar with that.
Well, let's talk about SPS's proposed jurisdictional allocation methodology and the proposed direct assignment of resources. You're the right witness for that, correct?
I suppose for clarification, I understand that PTCs typically have a 10-year value, so there's only 10 years, the first 10 years of a project in which tax credits are issued. So I could understand that the revenue requirement would go up. But I did not analyze the revenue requirement in 2040 to see how it compared to the 2030, which was the first year in which all of the projects were in service for a full year.
So 2040 would be when they have the highest revenue requirement, because the revenue requirement is highest earlier in a project's life when it's added to rate base, right? And then it declines over time.
Correct.
So SPS requested approval of a demand-based allocation method for the proposed self-build projects, excluding the proposed RPS project, right?
Correct.
And the proposed 12 CP allocator reflects each jurisdiction's average monthly coincident peak demand, capturing each jurisdiction's contribution to system peak loads over a full calendar year, and that's used to allocate production-related capacity costs, right?
Correct.
And then you propose to direct assign the RPS resource to New Mexico because of the RPS, right?
Correct.
Now, in the company's pending rate case, SPS has also proposed to direct assign the Cunningham Battery Energy Storage System, correct?
Can you ask that question again, please?
In its pending rate case in New Mexico, SPS has also proposed to direct assign the Cunningham Battery Energy Storage System to New Mexico, correct?
That's consistent with my understanding.
So issues regarding the relationship between the jurisdictional allocation of system resources and the direct assignment of resources is not limited to resources procured solely for the RPS, correct?
Can you ask that question again? Sorry, I did not.
Issues regarding the relationship between the jurisdictional allocation of system resources and the direct assignment of resources to New Mexico is not limited to direct assigned resources solely procured for the RPS, right?
I think that's fair.
The Cunningham BESS is proposed to be direct assigned to New Mexico because the CCN for that facility was denied by the PUC of Texas, correct?
Objection.
And which is?
That the Texas Commission's handling of that BESS and the proposal on the rate case is not at issue here in this proceeding, and I don't think it's within the scope of Mr. Trowbridge's testimony.
Mr. Stovall?
The issue regarding the Cunningham BESS is related to the relationship between the company's proposed jurisdictional allocation of system resources and any adjustment to that allocation for direct assigned resources, which, as we've already established through this cross-examination so far, is not limited solely to resources procured for the RPS, but also includes the Cunningham battery, which was denied by Texas.
Ms. Hardy?
I don't think it's relevant to the issues presented in this case or to the direct assignment of RPS resources, which is what is at issue here.
Permission to respond?
No, I've heard enough. Mr. Trowbridge, why did SPS assign the Cunningham BESS did SPS propose to direct assign the Cunningham BESS to New Mexico?
In the New Mexico FTY, I'm aware that I have an understanding that we requested recovery of that unit in the New Mexico FTY. That's
in the rate
my
case? You say in the FTI in the future test year?
Yeah, the future test year rate case.
Okay.
But I don't
Do you know why?
My understanding is that Texas declined their share of that unit. And in order to get recovery of the unit, it's being offered to New Mexico.
Very well. Go ahead, Mr. Stoffel.
Thank you. As we sit here today, Mr. Trowbridge, do we know which of the self-build projects the PUC of Texas will approve?
No, we don't.
Now, you were one of the sponsors for the company's response to bench request 1-4, right?
Yes.
And that question asked the company to identify the benefits that the Sandy Loam solar project, which SPS proposes to directly assign to New Mexico retail customers, will provide to SPS's New Mexico retail customers. You're familiar with that question?
Yes.
And the company's response to that bench request does not say anything about how New Mexico will receive credit for the capacity of the direct assigned resource, correct?
It outlines specifically the renewable energy benefits, so the RECs and the PTCs, as well as the market value, the full market value of energy sold to SPP associated with the Sandy Loam unit.
Thank you. My question was, the response does not say anything about how New Mexico will receive credit for the capacity of the direct assigned resource. It does not include anything about capacity, correct?
It does not.
Now, in this proceeding, the NMLCG proposed a methodology to provide New Mexico credit for the capacity of any direct assigned resources through an adjustment to the jurisdictional allocation of other system generation costs. You're familiar with that, right?
Yes.
Looking at your rebuttal testimony, page 22 of the PDF, page 18 of the testimony. Beginning on line 8.
Okay, I'm there.
There you argue that the jurisdictional allocation of other system costs should not be adjusted for the capacity from the direct assigned resources because the RPS resource is incremental to the MJB and was needed for generation of RECs rather than capacity, correct?
The fact pattern here that was presented was that this resource was being procured not for capacity purposes, but for RPS compliance. So its principal value is to procure RECs for compliance with RPS. Consistent with that, I've made a recommendation that the cost of the project is assigned to New Mexico.
I'm sorry.
Sure. When offering rate policy recommendations and cost allocation, for instance, with an RPS, a resource that's procured for RPS compliance, principally speaking, we've got to make a decision about potentially conflicting objectives, right? So while there is a small amount of accredited capacity associated with these units, the principal rationale for procuring these resources was the RPS compliance.
And you do not dispute, based on your testimony just now, that the RPS resource will provide some accredited capacity to SPS's system, correct?
Yes, that's my understanding. So it's my understanding that it has a projected accredited capacity in 2030 of approximately 5 megawatts during winter and about 9 megawatts during the summer period. And of course, that is subject to change as we move forward in time, depending on the market.
So
SPP.
turning to your rebuttal testimony on page 23 of the PDF, page 19 of the testimony. Beginning on line 16 and continuing through line 1 on the next page.
Can you clarify, are you talking about page 19 or 23?
I'm talking about page 19, according to the numbers on the bottom of the testimony.
Okay.
Beginning on line 16, continuing through line 1 on the next page. There, you respond to the NMLCG's proposed adjustment to the jurisdictional allocation of costs to account for capacity from the direct assigned resources, arguing that it would lower New Mexico's allocation of other system generation costs, effectively shifting a greater portion of those costs to Texas customers. Is that your testimony?
Yes.
You agree that the New Mexico Commission can only decide what costs should be recovered from customers in New Mexico, right?
So fundamentally, we're talking about a cost allocation methodology. And so the 12CP methodology looks at each jurisdiction's contribution to peak based on their actual usage. It doesn't have to do with the accredited capacity of individual units. That is, in essence, irrelevant to the 12CP cost allocation.
Well, to be clear, so you're talking about, you're using the relative jurisdictional loads, right? The demands from Texas and New Mexico to allocate system costs of capacity, correct?
Yes, that's correct.
And you agree that the New Mexico
loads.
Commission,
Yeah.
the New Mexico Commission can only decide what costs should be recovered through retail rates in New Mexico, correct?
Ms. Hashlamone.
Excuse me, Mr. Trowbridge, I'm asking a yes or no question. You agree that the commission in New Mexico can only decide what costs should be recovered through retail rates charged to customers in New Mexico, correct?
The proposed methodology seeked to shift costs away from New Mexico customers, which shifts costs to Texas customers. These are the members of the two jurisdictions that we serve.
Mr. Trowbridge, you agree that the New Mexico Commission can only decide what costs should be recovered through retail rates charged to customers in New Mexico, correct?
Objection.
Ms. Hardy?
I think he's answered the question.
I don't think he has. Answer the question, Mr. Trowbridge, if you know.
I think it's the commission's charter to determine cost recovery for its jurisdiction and class allocation and rates. And I would agree that the New Mexico Commission does not determine what costs are recoverable from the Texas jurisdiction.
And your testimony about shifting costs to Texas assumes the costs of direct assigned resources are fully allocated to New Mexico, right?
So the 12CP methodology, this is important. The 12CP methodology is a widely cost.
I'm sorry, I'm sorry, sir. I can.
Yeah.
I can barely hear you. The 12CP methodology is a.
The 12CP methodology is a widely accepted cost allocation methodology for utilities that are working in multiple jurisdictions.
And your
A
testimony,
the methodology is utilized to create a single pie to go through and allocate costs based on usage. So from a rate policy and allocation perspective, we're trying to use principles that can apply to both of our jurisdictions equally, to the extent that we can.
so back to my question, your testimony about shifting additional costs to Texas is based on the assumption that the cost of direct assigned resources are fully allocated to New Mexico, correct?
Can you state that question again?
Your testimony on page 18 about the improper allocation of additional costs to Texas still assumes that the cost of the direct assigned resources are fully allocated to New Mexico, correct?
Yes, I believe that these costs are being procured for RPS compliance, be recovered from the New Mexico jurisdiction.
Now, looking at page 121 of your rebuttal testimony, beginning on line 9.
Can you state the page again?
Page 21 is the
Okay.
number on the bottom, page 25 of the PDF, beginning on line 9. Are you there?
Of rebuttal testimony?
Correct.
Okay, on page 21, I thought you referred to page 25. I mean, I have row 9.
Page 21 of your testimony, line 9.
Okay.
There you argue that the SPP does not have a capacity market to compensate New Mexico customers for the capacity value of Sandy loan, correct?
I do.
While SPP does not have a capacity market, it does have a resource adequacy requirement, right?
It does.
And SPS, as a load responsible entity, must meet SPP's resource adequacy requirement, correct?
Correct.
And the company will use the accredited capacity from direct assigned resources to satisfy the SPP's resource adequacy requirement, correct?
Correct.
SPS complies with SPP's resource adequacy requirement on a system-wide basis, right?
It does.
So if the accredited capacity from resources that are direct assigned to New Mexico is used to satisfy SPP's resource adequacy requirement on a system-wide basis, then it is being used on behalf of New Mexico and Texas, correct?
Yes, that's accurate.
And
Mr. Stoffel, you're at your time. Do you want to borrow from somewhere else or?
I have one more question. I think I have a bit of a reserve built up from prior witnesses as well.
Go ahead.
The accredited capacity from any direct assigned resources will be used when determining any future capacity needs for SPS's system, correct?
I agree.
Thank you, Mr. Trowbridge. I have no further questions.
Thank you.
Thank you, Mr. Stoffel. I believe the next questioner who reserved time was OPL. Mr. McMillan?
Your Honor, I don't believe I reserved any time for Mr. Trowbridge.
Okay. Yeah. My sheet's getting pretty marked up. Let me look at it. No, you're right. You didn't. Ms. Drake, you reserved 20 minutes?
And I'm gonna mark up your page even bit more badly. Sorry. I don't believe I have any questions for this witness, but if you could move my time to Mr. Goodenough, that would be appreciated. Thank you.
Okay.
Thank you.
Thank you. Ms. Lynch, I believe that you or Mr. DeSalen reserved 15 minutes.
We did reserve time, but the questions we had have been answered, and I don't have any for Prosperity Works.
Okay. You had reserved 15 minutes. Waive that. Okay. I believe, Miss Sir, you reserved 5 minutes for Sierra Club.
Yes, hearing examiner, and my earbuds aren't working. Can you hear me
I
sufficiently?
can hear you.
All right. I just have a couple of questions.
Go ahead, please.
Thank you, hearing examiner. With regard to bench request number 2, that was the bench request in which you were a sponsor. The response states the removal of the Oneida 2 solar project from SPS's requests did not result in any changes to the jurisdictional allocation percentages for the multi-jurisdictional baseline self-build projects. Can you simply confirm the flip side of that, that the addition of the Oneida 2 also did not and would not have affected the jurisdictional allocation?
That's correct.
And that is because those costs are direct assigned to New Mexico customers before you determine jurisdictional allocation of other resources, correct?
Jurisdictional allocation in this case was determined based on forecasted use system. So it is the forecasted peak megawatt use per month averaged of each jurisdiction. And so individual projects being added or subtracted doesn't impact that allocation.
I don't think you've answered the exact question. Let me try again. Is it the jurisdictional allocation methodology, which involves first direct assigning New Mexico customers RPS resources? Is that why the addition or subtraction of an Oneida 2 would not affect the jurisdictional allocation in your AGT2 referred to in the response?
So AGT2, attachment AGT2 to my testimony, presents a use of system. And so AGT2 will present a simple statistic of, well, it's some statistics, but ultimately it's a percentage use of system.
Like,
So
can
it
I
is.
redirect you, sir? I still don't think you're getting at my question. I'm sorry for the interruption. But my question is about the allocation methodology. Is the direct assignment as the first step of RPS resources the reason why in the second step, when you're allocating other resources, whether or not you add or subtract Oneida would not change that jurisdictional allocation in AGT2? That's my question.
So let me answer it this way. I think I I can get to your point or your question.
It was a
The
yes or no
cost.
question.
I think
Okay. We're not gonna get into interrupting the witnesses after a question. We're going to have a nice measured give and take. So, Mr. Trowbridge, please continue.
Okay. So the methodology itself is a simple methodology that creates a percentage. Those percentages are then applied to revenue requirements. So when we talk about the MJB portfolio, we would apply those percentages to the revenue requirements in the MJB portfolio. If, for instance, instead of doing direct assignment of the costs of the RPS resources like Sandy Loan or Oneida 2, if those were included in the MJP portfolio, or if those were allocated based on the 12CP methodology, it would change the costs that were allocated to the jurisdictions.
Okay, but they were not. So my question is, did the direct allocation methodology, is that why, because you assigned Oneida 2 to New Mexico first, is that the reason that whether or not you add or subtract it, it would not change the jurisdictional allocation of costs of resources in AGT2 to New Mexico customers? I'm asking about the reason why that impact doesn't affect your jurisdictional allocation. Do you understand my question?
No, the direct assignment does not change the jurisdictional allocation, whether it was included or excluded. It
Thank
does
you,
not
sir.
change the jurisdictional allocation percentage.
Okay, thank you. I think that was the answer. All right, I want to ask you one final question. You indicated to Mr. Stoffel that the direct assigned renewable resources that have capacity and serve SPS's system as a whole, including Texas customers. My question is Texas being assigned, or do they pay for any of the costs of that capacity from New Mexico renewable resources that serve SPS's system? Yes or no?
Can you ask that question again?
I'll try. I did not write it down. My question is whether Texas customers who are served by some of the capacity of New Mexico direct assigned resources, do they pay for that capacity?
objection.
Ms. Hardy?
It's not clear to me what resources Missouri is referring to. SPS is proposing to directly assign this Sandy Loan project to New Mexico, but it's not clear to me if she's asking about some other resources that are directly assigned, or if she's asking about how the direct assignment impacts Texas in this case. I think it's a confusing question.
May I respond?
You want to clarify exactly what project you're referring to, Ms. Sir?
Yes. New Mexico RPS resources that have capacity that serve system like Oneida that are directly assigned RPS resources. That's my question.
Does that clarify for you, Ms. Hardy?
I suppose, well, I'm not sure there are. I still don't understand what directly assigned resources Missouri is talking about. She hasn't asked if there are any. So that's the problem, I think, with the question.
I'm going to overrule the objection. Answer if you know, sir.
I can say that the treatment of Sandy Loam as the full cost assignment being to New Mexico is very similar to the way that we treat Sun E, which is a resource that I understand was procured for RPS purposes. And so it's direct assignment. And so the full amount of costs, direct costs, are assigned to New Mexico.
Hearing examiner, could you direct the witness to answer my question?
I believe the question is, question posed, New Mexico RPS resources that have capacity that serve a system, you say like Oneida, I think you meant Sandy Loam, that are directly assigned if they serve Texas, if Texas customers are served by some capacity of those resources, do the Texas customers pay?
Texas does not pay for resources that are directly assigned to New Mexico.
Okay.
Yep.
No further questions. Thank you. Thank you, Mr. Trowbridge.
Thank you.
Thank you. Mr. Marcus, I believe the Department of Justice has reserved 60 minutes for Mr. Trowbridge.
Good afternoon, Madam Hearing Examiner. I don't think we'll be using the entire 60 minutes, but I do have a few questions.
Go ahead, sir.
So first of all, Mr. Trowbridge, you talk about the 12 CP allocator and the jurisdictions in terms of allocating between jurisdictions. You talk about the average monthly coincident peak demand. Is this based on historical data or projected data?
For the purpose of the illustrative example in the case, we use forecasted data.
You are using forecasting. All right. So you said that these forecasts are illustrative, right? Illustrative, right?
Yes.
So you provided the commission with a highly specific bill increase figure for the residential customers. I believe it's on page 37 of your testimony. Highly specific. 47.05%. So it's to the of an increase in the rate in the and so you went to the 100th of a percent. Does this provide any sort of guarantee that this is what it's going to be? This is going to be the percentage?
No, the bill impacts were illustrative. So what I did in my testimony is I laid out the methodology that I followed to create those bill impacts. But ultimately that's subject to future commission decisions about cost allocation and recovery.
So you can't actually guarantee that the final bill impact for a residential customer won't be 50 or 60% higher once these projects are built, can you?
Yeah, the example that I provided wasn't intended to be a guarantee of percentage bill impact, for instance.
Now, you state that SPS is not seeking immediate cost recovery in this case. It's not actually seeking to have any sort of cost baked into the.
I'm sorry, Mr. Marcus, can you get closer to the microphone? Go ahead.
Oh, sorry. So you're not seeking immediate cost recovery in this case, Mr. Trowbridge.
The company's not seeking cost recovery in this case. It is seeking to establish the 12 CP methodology for jurisdictional cost allocation.
But you are asking for a certificate of public convenience and necessity, which is a legal finding that these projects are necessary and in the public interest, isn't it? What you're seeking in these proceedings.
Can you state that again?
You're seeking a CCN, right? And that's a legal finding that these projects are necessary, isn't it? Isn't that what you're looking for?
Objection.
Ms. Hardy?
I think that the question calls for a legal conclusion, and I think that Mr. Trowbridge is testifying in this case regarding the projected rate impacts and the requested jurisdictional allocation.
I'm trying to get at that they are that they're trying to establish that these projects are necessary and therefore perhaps prudent.
Well, you need to respond to the specific objection, sir.
It's not specifically a legal conclusion that I'm asking for. I'm asking for a discussion as to whether whether they're trying to establish that these projects will be used and useful in the future in this proceeding.
Well, then perhaps you might not ask it in terms of a legal finding. And if you take that part out and ask them if they're necessary, if that's what you're looking for, sir, then I suggest you do that because I sustain the objection.
All right, Mr. Trowbridge, are you arguing in this proceeding that these projects are necessary and prudent?
I think the company as a whole is presenting its case for the need of these resources. But I, in my testimony, really don't assert to that. My testimony in particular is a request for the 12 CP methodology, the rationale and history of the use of 12 CP, and then an illustrative bill impact example and methodology to which I got to the bill impacts.
So your 2030 projections, they rely on a forecasted revenue requirement of $603 million for the New Mexico share. Is that right?
Let me confirm.
What?
Is there a page in my testimony by any chance that you're?
Well, it's actually, actually, I'll revise that. It's actually 553 million net increase in revenue requirement attributable to the self-build projects. That's
okay. I have my bill impact reflects a revenue requirement in 2030 of approximately $532 million. And that is in attachment AGT 4, second errata. And that includes the direct assignment of the Sandy Loam project, related PTCs, and the projected avoided energy costs in that year.
And it's also due to certain increase in demand, is that right? Electrification and I think you're freezing. Electrification of the Permian Basin and also data centers, the building of data centers.
Objection.
Ms. Hardy?
That's outside the scope of Mr. Trowbridge's testimony. He's not addressing demand.
I withdraw that. But if your load forecast, let's say you are forecasting a load, SPS is forecasting a load, the small residential customer will be stuck paying for this excess capacity. If all this excess capacity is built and it turns out not to be needed, the small residential customer would be stuck paying for it.
Objection.
Ms. Hardy?
Argumentative. Assumes facts not in evidence.
Mr. Marcus?
There has been prior testimony by other witnesses that a lot of this extra capacity is going to be necessitated by an increase in demand. And I think it's a simple common sense question, not really, I'm not trying to argue with him, but more of a common sense question that if the demand doesn't come to pass, then the small residential customer would be holding the bag on this. And I think it's within his, because he is talking about rates, he's talking about the calculation of rates and talking about the methodology, that if without excess demand, you're going to see a greater increase in rates for the more constant, the small residential customer that's already there. Is that correct, Mr. Trowbridge?
Well, I think the specific objection was argumentative, assumes facts not in evidence. And your response is, you don't think it's argumentative, and you don't think it assumes facts not in evidence?
Well, I believe it's a simple yes or no question, not in terms of facts not in evidence, we're talking about increase in rates. We're talking about increase in revenue requirement. And so what if this increase does not come to pass? They're talking about projections. They're talking when he mentioned earlier that when calculating the jurisdictional allocation, he's using projected demand rather than historical.
I'm going to sustain the objection, but I believe that you asked in your explanation a question that was permissible. Mr. Trowbridge, what happens to the proposed increase if the demand projections and allocations don't happen? If you know.
If we experience an increase in revenue requirements, and there are not sales that offset those revenue requirements, then the company would seek to increase rates on existing customers.
Go ahead, Mr. Marcus.
All right. So on page 37 of your direct testimony, you mentioned a bill change of 47.05% increase for residential customers. For small general, you anticipate a bill change of 51.61%. However, for primary general, you only anticipate a bill increase of 28.49%. What exactly do you mean by the primary general customer?
Primary general is a voltage class, so it is a service, a rate class that we serve.
And what sort of custom? Oh, sorry, I didn't realize.
Oh, it's that is at they're served on our primary system. So we have customers that are served at transmission voltage. which can be 115 plus or 69, between 69 kV and 115. And then below that, you have a primary distribution system, and customers served at that level are considered primary general customers.
And what sort of customers would be served by this voltage?
Typically larger industrial customers, larger commercial and industrial customers are served at that voltage.
And so why should a small residential ratepayer shoulder a percentage increase nearly double that of these large industrial customers?
So it's in cost allocation. So when we look at AED 4CP, the methodology for applying demand costs across our customer base, residential customers typically pay more because they are lower load factor customers. So in order to serve that customer, in order to serve those customers, they typically use more capacity on a kWh perspective than higher load factor customers like our large industrials, PG, 69 kV and 115 kV customers. So their service is automatically more expensive. The cost allocation methodology, so when we look at resource procurement, we apply that in a non-discriminatory way, which is we look at the cost of the system, and then we apply that based on customers' use of system.
And so you say you use this AED 4CP allocator. Are there other allocators that you can use?
For cost allocation?
Yes.
There are different cost allocation methodologies that can be employed.
If you put more weight on average demand, wouldn't that shift some of the cost burden away from the peaking residential users and towards the flat load industrial customers?
So average demand looks like an energy allocator. And in this formula, to shift costs toward average demand or utilize an energy allocator, it would shift costs to the high energy users, the high throughput. The reason that that's inappropriate is that these costs are, for the most part, when we talk about base rates, self-build projects, we're talking about fixed costs and fixed costs of capacity. So while you're spreading that out over a larger number of units, and that may shift costs away from residential and toward commercial customers, it does not comport with cost causation, is what I would recommend.
Could you simply do a separate tariff for the new large load customers? After all, these are the customers that a lot of this excess capacity is being built for, right?
Objection.
So
Ms. Hardy?
I don't think that the question is accurate. I think it's misstating testimony in this case. To the extent that the question asks or assumes that all of the capacity is being built for large load customers. I think the testimony is there's our system resources.
Mr. Marcus?
I just have, I'm gonna rephrase it as, and this will probably be my last question. Is SPS considering a separate tariff for new large load customers?
It is considering large load tariffs currently.
I don't have any more questions. Thank you very much, Mr. Trowbridge.
Thank you.
In what way?
Considering large load tariffs.
Huh? You're considering different allocations? You're considering what?
Broadly speaking, nationally, I think that what we've seen is an increase in generation costs, and a lot of demand growth has been, and maybe not as much in our system in particular, but from a national perspective, I think that a lot of growth in demand is being driven by data centers. And so there are elements about the increase in costs, credit related issues, contracting related issues that we are considering putting in place for large customers to attempt to insulate our existing ratepayers and those that are less speculative.
So do I interpret that to mean that potentially SPS is considering redoing the large load tariff to include more of the costs that might be caused by that type of user?
We don't have a filing at this point, but I believe that, for instance, the Attorney General, New Mexico Attorney General, has issued an interest in insulating existing customers from the cost impacts associated with data center growth and rate impacts. And so we're taking that under consideration in evaluating ongoing rates. At this point, we haven't proposed anything.
Very well, sir. Thank you.
Thank you.
Do you want to tell me anything else?
No, it was pretty much the same thing. Thank you.
Okay. I believe that staff reserved 45 minutes for Mr. Trowbridge, Ms. Lang, Ms. Amer. Is that right?
I'm hearing examiner. I do not know if we will need all of that time. But
Go ahead.
Excuse me, Ms. Amer, excuse me. Do we want to take a quick break here? We've been at 2 hours. I see Mr. Lee nodding, a nonverbal nod,
Okay.
nonverbal affirmation. Okay.
Sure.
10-minute recess, everybody. Thank you.
Mr. Lee, are we good?
Yes, Judge.
Very well. We're back. Yes. And I believe, Miss Amer, you have 45 minutes.
Thank you. Good afternoon, Mr. Trowbridge. My name is Judy Amer, and I represent the New Mexico Public Regulation Commission's Utility Division staff.
Good afternoon, Mrs. Amer.
Thank you. You know, a lot of the questions I was going to ask you have been asked, but I am going to ask you some questions. Do you agree that cost allocation issues are complex issues?
Yes, I feel like cost allocation issues can be complex.
And do you agree that cost allocation issues are often resolved as contested issues in general rate cases?
I think fundamentally, I think that some of the issues, like the ones that we're asking for here, the 12 CP determination, should have guiding principles that are based on the, kind of the highest level intent of the resources being procured and the cost allocation between the jurisdictions. However, I think if we step a little bit further into allocation between rate classes, I think those issues are good to determine in a general rate case, because I think that the commission and the parties need an opportunity to work through reasonable compromise on the increase in rates and impact to their customers.
Thank you. And is it fair to say that issues regarding energy affordability are very important to public regulation commissions in general?
Yes, I agree.
And therefore, are key issues regarding affordability and overall cost, revenues, and allocation and rate design would be best addressed in a general rate case?
So I think that there are different levels of cost allocation and issues that are good to work through in a general rate case. In particular, on the 12 CP recommendation here, I think it's important that fundamentally we're procuring these assets, and it's understood the cost approximation to the jurisdiction, to New Mexico. New Mexico is approving these resources. They're approving these resources based on how these resources will facilitate capacity and reliability requirements. And so we're trying to establish that on the front end, as opposed to have ambiguity around that. When we get into the individual classes, I tend to agree that there will be a number of different issues around affordability that we'll have to navigate.
So it would be fair if the commission decided to review cost allocation in the context of a general rate case.
Objection.
I don't know if that was a question or not.
That was part of my objection.
Would it be fair to address cost allocation in a general rate case?
Are there specifics To that question, are we differentiating between jurisdictional cost allocation, or is there some framework that maybe I can answer that from?
Would it be fair to address class cost allocation issues in general rate cases?
I think that's what we anticipate and have suggested here, yeah.
Would it be fair to address jurisdictional cost allocation issues in a general rate case?
I think fundamentally, we're reviewing all of the cost allocation metrics. However, for the purpose of the CCN, we're trying to establish the guiding methodology for cost allocation between the jurisdictions, the methodology, to ensure that we have an appropriate methodology to then seek recovery within the jurisdiction.
Did SPS provide a cost of service study in this case?
No.
Do you agree that issues such as overall costs, revenues, allocation, rate design are addressed in a general rate case where a cost of service study has been provided?
Yes.
Okay. And SPS didn't do a cost of service study in this case, but did address allocation issues. Is that correct? And as well as rate recovery.
Well, objection.
Ms. Hardy.
I think it's misstating the testimony and the evidence. SPS's testimony is that we're not asking for rate recovery in this case.
Ms. Amer?
Yes, I'll rephrase the question. SPS did not provide a cost of service study in this case, correct?
Should I respond to that?
Well, it
Okay.
looks like she's withdrawn her question, or she's breaking it up. So yeah, go ahead and respond if you know, Mr. Trowbridge.
Okay. So a class cost of service study typically tries to identify various cost streams and then go through and allocate those cost streams. But there are multiple different cost streams. So it could be distribution costs, various distribution types of costs, transmission costs, generation costs, et cetera. In this case, the items that we're presenting on are the cost of service associated with these generating resources. And we also present on production tax credits. And then we also present on avoided energy costs, in particular associated with the Sandy Loam facility, because that's being direct assigned. We did present our framework for cost allocation for illustrative purposes, right? So we are not seeking recovery and we are not instructing really what the costs will be. My testimony anticipates that will be subject to a future proceeding, base rate proceeding or otherwise. The only request here from my testimony is the jurisdictional allocation methodology. And that is primarily to instruct a methodology for cost allocation at the highest degree for this jurisdiction.
So you're requesting a methodology to be used?
for the
I'm sorry, a
jurisdiction.
methodology to do, excuse me, you're requesting a methodology to do?
To be used. Is that correct?
Yes, we are requesting the 12 CP methodology to instruct cost allocation for these resources.
And is it correct that you're using the AED/4CP method because it's been used in previous cases?
Yes, I did present cost allocation using AED/4CP, which is what we typically use for capacity and demand related charges. I'll add that we have in New Mexico, we have a long history of employing rate moderation adjustments on top of the AD/4CP allocation. So it is that, mechanically we look at allocation based on cost causation principles. But then ultimately there is some shift to moderate bill impacts to particular customer groups that might be, impacted.
Okay, and just to nail it down, you're using this 12 CP method for class allocation and the AED/4 CP method for jurisdictional allocation. Is that correct?
That's incorrect. So
Okay.
it's the 12 CP methodology is used for jurisdictional allocation.
Okay, sorry.
And then once you've determined the cost allocation to the jurisdiction, then you're applying an AED/4CP methodology for the class allocation. So
Okay.
the individual classes, residential, small general, secondary general, etc.
Okay, so you said that these projects will be addressed in a future rate case. Is that correct?
I am only seeking, or we as a company are only seeking approval of the 12 CP jurisdictional allocation and anticipate that we'll seek approval and cost allocation, class cost allocation in a future rate proceeding.
So in the future rate proceeding, will you request the AED/4CP method to be used as well?
I anticipate that we may use AED/4CP at this point. That is our precedent and has a good mechanical cost causality justification.
Is that the method that you're requesting in the current rate case?
Yes, I have used AED/4CP in our current FTY rate case request before applying gradualism adjustments.
And you said that you used those methods for illustration purposes only, but doesn't it appear that it's more than purely illustration since you are requesting it in the current rate case?
Well, I think this proceeding, we're not asking for cost recovery or allocation in this proceeding. So it is illustrative. And as I mentioned, it does not
reflect gradualism adjustments, that we've deployed historically, or adjustments that we've reached through a settlement in our rate case proceedings.
Well, I'm glad because of that kind of segues into the next question, which has to do with bill impacts. According to your direct testimony, page 36, is it correct that SPS projects the residential bill impact to be approximately 47.5%, no, 47.05% by 2030?
So as a correction to that, in my second errata, the residential bill impact is corrected to be 44.3%. But I can agree fundamentally that it's over 40% and
over 44%. Is that correct?
that's accurate.
In 2030, and that's the first full year all the self-build projects are expected to be in service. Is that correct?
That's correct.
And this estimate is only for 7 of the 16 projects in SPS's final preferred portfolio. Is that correct?
This is for only the self-build projects in this portfolio. That's accurate.
So is it fair to say that there will be residential bill impacts from the other 9 projects that are part of SPS's final preferred portfolio?
Yes, that's right.
And is it correct to assume, therefore, that the total will be more than the over 44% bill increase for residential customers?
Based on the methodology that I followed here, yes, that's correct.
Given the magnitude of the bill impacts to residential ratepayers associated with the cost of these projects, in this case alone, is it unreasonable to allow an affordability analysis of the current proposals in the context of a general rate case?
Objection.
Ms. Hardy?
I think the question is confusing and I don't know, unreasonable for whom? I mean, the question is would it be unreasonable?
Would you like to clarify your question, Ms. Amer?
Yes, thank you. Wouldn't a thorough review of the impacts of affordability be best addressed in the context of a general rate case?
A couple of thoughts that I have to that question. Well, I don't know. I mean, why don't we start here? I don't understand what affordability impacts in particular you think would be best studied in a general rate case. So I guess the answer is, why wouldn't we want to try to understand that here to a certain degree?
Regarding I'll clarify that the affordability impacts are the impacts to bills of ratepayers. And therefore, the question is, in a general rate case, there'll be other increases to bills. There will be other increases to customers' bills. Is that correct?
I can't say.
Well, can you say that SPS brings rate cases to increase their rates? Is that correct?
Objection.
Ms. Hardy?
Well, I think that the reason SPS files rate cases.
Don't tell me. Don't testify.
I mean, I think it's outside the scope of Mr. Trowbridge's testimony. The reason for filing rate cases.
Ms. Hardy?
Miss Amer,
Sorry, Ms.
I
Amer?
can rephrase the question. Do applications submitted by SPS in rate cases 99% of the time contain a rate increase?
I don't have any statistics to prove that out. Rate
Approximate.
cases could be to decrease rates or increase rates. Generally, I would agree that rate cases in recent history have been to reflect an increase in costs when those costs are not offsetting sales growth.
And given the magnitude of the increase in bills from just this case, wouldn't it be fair to review it in a holistic affordability analysis?
Certainly appreciate the need to analyze affordability in a holistic manner. For the purpose of my testimony in this case, and the request in particular around the jurisdictional allocation, I think it is especially important that that we have a guiding methodology or principle in the cost allocation between the jurisdictions. When we just maybe to add a little bit to that, when we look at growth, generally in this case, close to 80% of the growth is expected to occur in New Mexico. So it's important that when we procure these resources, that there's, there is a way that we can anticipate as a company, the way that we can recover, and as customers or as a jurisdiction, the magnitude of those costs.
Isn't it correct that the commission declined to address rate-making issues such as jurisdictional allocation in case number 23-00252?
I agree and understand that the commission broadly declined to address rate-making issues, but their decline in that case did not address the individual cost allocation issues, which was part of the reason that this request was different than the last request, fundamentally.
And the basis of that decision to decline to address rate-making issues, including jurisdictional allocation, was to review rates holistically in a rate case.
And I don't have in mind the exact rationale. for that.
Piecemeal rate making is a regulatory concept, is that correct?
It is a regulatory concept, and I don't think that we are establishing rates here. I don't think that we've requested to establish rates. We've simply requested a methodology for jurisdictional allocation.
Do you agree that an issue that the commission should consider under the CCN net benefit test is affordability of customer electric rates?
I haven't testified to the net benefit test in this, and so I don't know whether it should or it shouldn't.
Okay. But just regarding benefits and burdens, do you agree that it's a burden to have an increase in your electric bill?
I think is it a burden to have an increase in your electric bill? I don't think that anyone is looking to pay more for their goods and services. So sometimes, unfortunately, we are the bearers of necessity, which is cost of service is increasing. And we're experiencing, right, a lot of the things that we're seeing currently as a utility, and part of this procurement is to serve generation replacement. So there are retirements and replacements that are happening here. We are also responding to changes in planning reserve margins. A lot of the changes in planning reserve margins are driven by need for reliability and some of the environmental events that we've seen recently. At least that's my perception. So these just happen to be a product of the requirement to procure these resources.
So it sounds like you're saying, and correct me if I'm wrong, that there are increased costs that need to be recovered by SPS.
I think all else equal, I think that there are an increase in costs that are associated with this. We're also experiencing load growth. So growth is also a part of our responsibility to serve is to serve load growth in our jurisdiction. And we've got very important businesses that are looking to locate in our states and in our jurisdictions. So we're seeking to fulfill that responsibility.
Therefore, you would agree that allocation of these costs is a very important issue.
I agree that rate setting and broad inclusion of stakeholders in the commission is important in going through and paving a path forward for our investments.
So why is there an immediate need to address allocation of costs in this matter right now?
At the highest level, we have brought forward a portfolio of resources. And we've been able to go through and present the annual revenue requirements associated with those resources. To understand for the state of New Mexico, for our retail customers, their share of these costs, it's important for us to establish a methodology for cost allocation. So before we take it any further, the simple presentation is the bulk of system planning and the division between our jurisdictions. And so those two elements help to reduce ambiguity about the potential cost impacts of these resources, at least from a jurisdictional perspective.
But do you agree that circumstances could change between the time that this case is decided and there's that future general rate case that you mentioned that would warrant a change in allocation methodologies?
Know that I don't know that I see an event that causes a need to change jurisdictional cost allocation methodologies. Because we're recommending a methodology, we have the ability to adjust for changing circumstances. So if growth were to occur in Texas, they would receive their share of the costs, as opposed to so essentially, if there was a shift between our jurisdictions, where there was higher growth in Texas, those costs would shift under this methodology. Right, and that's really different than us, for instance, coming in this proceeding and truly attempting to establish cost allocation based on our growth projections.
So, okay, so I'm a little confused. So you're saying that if circumstances change, you could change this request for an allocation methodology in the future?
So no change so I don't anticipate a need to change the 12 CP method of cost allocation between our jurisdictions. If the Texas jurisdiction was growing at a greater pace than New Mexico, then Texas would receive a greater share of the costs of the system.
Under the current methodology?
So that under the recommended methodology, it has the ability to adapt for changes in load growth.
Okay, I want to ask a question about Ms. Leyba Tercero's direct testimony on page 34, where she states that according to 1.8 of SPS's response to Sierra Club's first set of interrogatories and requests for production, the company states, quote, at this time, SPS estimates that New Mexico customer bills may increase approximately 65% by 2030 directly as a result of the final preferred portfolio, excluding the Oneida 2 project. This estimate may change to the extent that there are further changes in the final preferred portfolio, but this value represents SPS's estimates at this time. Given that as a backdrop, what methods is SPS planning to use to mitigate rate shock?
At this time, that's outside of the scope of my testimony and recommendations.
Do you know whether this has been discussed by SPS?
I mean, there's certainly a concern around affordability impacts. You know, I think that we would have to get to what would I say? Can you ask the question again, please?
Have there been discussions of or plans that you directly have knowledge of for mitigating rate shock to SPS's customers?
So in particular, in the company's rate case that it's filed, the New Mexico FTY, we have proposed a gradualism adjustment to adjust company bills to perform a rate moderation exercise.
Thank you. Okay, you got a lot of questions about direct assigned resources such as Sandy Loan. And is it correct that you testified in your rebuttal, page 21, starting at line 9, that SPP does not currently have a capacity market that could compensate New Mexico's for the capacity value of Sandy Loan?
I did testify that the Southwest Power Pool does not currently have a capacity market, and the intent of that was to talk about that here what we have is we have some incidental capacity that shows up with the entering into the Sandy Loan transaction. And for instance, we might have the ability to go through and monetize that. Right? So we have the ability to monetize the energy on the system. So we have the ability to sell the generation from Sandy Loan into the market and receive market compensation for that. But in this case, we don't have the ability to sell that capacity, and it also doesn't, because we don't have that, it doesn't facilitate something simple like knowing what the value of that capacity might be.
So with respect to the energy market sales that you were saying that you can do, right?
Right.
Okay. For Sandy Loan, will New Mexico customers get 100% of the benefit of those market sales? Energy market sales?
Yes, they will.
Okay. You did say that Sandy Loan assisted the SPS system capacity for purposes of the SPP compliance, reserve margin compliance. Is that correct?
Ultimately, it contributes some capacity value. So when we look at loads and resources, on a system basis, we see that there is a contribution from those units. For the purpose of my testimony and my recommendations on cost assignment, I've pointed out that that unit was not procured for capacity planning purposes, and that the primary reason that it was, and the primary reason and the primary value of the unit is its renewable generation. And that's why I've recommended to New Mexico.
I understand Sandy Loam was not procured for the purposes of capacity, but given that Texas customers are getting some system capacity, do you think it would be fair for those Texas customers to pay some amount for that?
I think fundamentally, rate policy typically involves reasonable compromise between conflicting objectives. And here, what we're talking about is we are talking about that we have a facility that was purchased for RPS compliance. Substantially all of its value is associated with its renewable generation. It was not procured for capacity purposes. It did not avoid capacity purchases in the exercise that was the IRP and RFP in this case. So the compromise that we make is we look at the primary objective and we look to assign cost allocation based on that. And so in this case, we have this incidental value. So it's about an 189 megawatt solar facility. It is deployed on an existing point of interconnection, and energy from this unit can displace thermal energy that would otherwise be provided at that same POI. There's a small incidental capacity value that exists in it, but the primary fact pattern that exists here still suggests that the should be fully assigned to New Mexico, from my perspective.
Couldn't SPS think of a way to compensate New Mexico for that amount of capacity that Texas gets from the 100% direct assigned Sandy Loam resources?
So I've had a chance to think about this a little bit. And the first question that I asked myself was, what is the appropriate level of compensation? And so, as I mentioned, or what is the value? Not what is the compensation, but what is the value of this excess capacity? And so, at least a couple of the thoughts that I had were, one, we don't have a capacity market. And so I included that in my rebuttal testimony. That would give us a place for us to go through and measure this. Another opportunity potentially would be through a bilateral transaction. So we could seek to sell, for instance. Right? I don't know that we would do this or not, but we could seek to sell, that 5 megawatts of capacity. I do have questions about the marketability of that 5 megawatts, because it is on a restricted POI. It isn't from a dispatchable generator, and so I think that there are some marketability limitations of those 5 megawatts. That may be a matter that we can seek to find common ground on. That said, I think fundamentally the cost of the Sandy Loam unit should be assigned to the New Mexico jurisdiction because of its principal rationale for procurement.
Thank you. I don't have any further questions.
Thank you very much.
Thank you.
15 seconds to spare, Ms. Amer. Okay. Hearing examiner Schaefer, do you have questions for Mr.
Yes,
Trowbridge?
Yes, just a few questions. Thank you. Mr. Trowbridge, thank you for all your patience. It's been a long day. Feel free to take a breath and clear your thoughts for a minute. I just have a few questions. You are the now Director of Pricing and Planning for Xcel Energy Services Incorporated. Is that correct?
That's correct.
I'm wondering if you can explain to us the relationship in the between Xcel Energy Services Incorporated and the Pricing and Planning Department. I assume it's a department, and SPS.
Yeah, for all intents and purposes, I work for SPS. All of my work is focused on the SPS jurisdiction. Xcel Energy Services, right? So just broadly, Xcel Energy Services typically houses a lot of your common functions. So that'll be finance, accounting, billing, where the duties are common, and so typically you have even within those within the service entity, you typically have folks that are assigned to a particular jurisdiction. So like our accounting teams, they're focused on SPS accounting, for instance, our fuel settlements, et cetera, et cetera. So for the purpose, and it really is no different for me. My position serves SPS entirely. I have a team. Part of my team works in Amarillo. Part of my team works in Santa Fe. I have a team member that works in Denver. And part of that orientation, it's helpful for us to be part of the service company from a taxation perspective, income tax perspective. And so I guess beyond that, those were just kind of my initial thoughts.
And go ahead, Mr. Trowbridge, didn't mean to interrupt.
That's it.
I was just also curious about in your testimony, as you described your responsibilities as manager of pricing and planning. Have they changed now that you're a director, or do they still include what you included in your testimony?
They're functionally very similar. I've been with the company for going on 17 years now at this point. And I think in all of our jurisdictions, and including SPS, pricing and cost allocation has taken on substantially more work. And also the team is expanding. And so fundamentally, very similar principles, just expanded responsibilities.
Are you the ultimate authority, so to speak, or do you have the last word on determining SPS's pricing strategy and pricing requests?
I make recommendations to our team. So, I report to Zoe Lees. She is our VP of policy and regulatory at this point. And then we report up to Adrian Rodriguez, our president. And so there's a chain of recommendations that are made. And then ultimately as a company in multiple jurisdictions, we can try to utilize the expertise of some of our other jurisdictions in maybe the tact and breadth of pricing options as well.
So if I understand correctly, you work in your team working for Excel Energy Services Incorporated makes recommendations, and those are adopted or not by SPS and their senior management?
I think that's fair to say.
I noticed in your testimony you included references on multiple occasions to rate riders. Is that correct?
I can't think of the particular rate riders in my testimony that I referred to, but I'm comfortable with the topic.
What is a rate rider?
So rate riders, typically an easy example would be the fuel rider, the FPP CAC in New Mexico. And so typically what it is that you've got a particular set of costs that you're going through and you are collecting. And maybe use of a rate rider may be permanent or it may be temporary. With our fuel rider, the FPP CAC, a majority of the costs that we go through and collect will be fuel, purchase power costs. We also provide the production tax credits. And then we also have all of the market interactions where we're selling all of our energy and purchasing it back. So there is no profit incentive associated with those transactions. And because of that, and because of volatility, the use of a rider is a better mechanism than going through and setting base rates based on forecast or an expectation or a historical perspective.
Go ahead, Mr. Trowbridge. Sorry to interrupt.
So just to kind of expand on that, a couple of other riders that we have an energy efficiency rider in New Mexico. We have the RPS rider. We have the grid modernization rider. We have a transportation electrification, kind of an EV rider. And typically, I guess what I would say sometimes you have special interest projects, potentially where you've got volatility associated with your recovery of a certain set of costs, or it may be project-based, like the grid modernization rider, right? We've got a significant amount of costs, some volatility as to when those are going to happen. And so the rider provides essentially a true-up mechanism. It also allows us to go through and change rates on an annual basis to reflect where we are with that project implementation, for instance.
If we could look at your testimony on page 9.
Direct testimony?
Yes, that's correct. Thank you. Your direct testimony, okay. Page 9. You are asked, maybe by yourself, in the question on page 1, Is SPS seeking to recover the costs of the projects included in the final preferred portfolio in this proceeding? And you respond no, and then you provide various options or possibilities for mechanisms that could be utilized for cost recovery for the expenses incurred in this application for the portfolio generation assets. And can you just tell us a little bit about why you included those and how the final preferred portfolio assets might be, their costs might be recovered through those example mechanisms?
Sure. So, in particular, what we have is we have self-build projects. Those are capital investments that we are making, that SPS is making, and financing. Traditionally, these types of projects are recovered through base rates. So you have an increase in base rate, or rate base. And so traditionally, we would go through a base rate case. Let's just take a look. So there were a couple of different things going on here. So let's just go kind of point by point. On page 9, the first item that I list there is a rider under section 6216-26E. There was some anticipation at the time of our original filing that a number of these projects might be certified as economic development projects. And in particular, I think that the Gaines facility was one of those units that we were seeking economic development for. Being able to take a facility, so with, I would say, the ability to file, my understanding is under 6216-26E, that the utilities had the ability to propose a rider mechanism. And so on that one in particular, what we have is we have, number one, we have a large facility with a significant amount of capital. The rider mechanism allows us to depending on how it's deployed or proposed, rider mechanisms typically allow us to go through and provide a forecast or very quickly enable rate recovery. And so we don't have the regulatory lag that's associated with a significant investment where the company is incurring costs of service immediately at the time of the time the unit is placed in service. And so it just provides a greater continuity. And so anyway, we were anticipating that potentially with the Gaines unit. I think especially when you've got significant units or significant costs that may be subject to true up or the costs are changing over a period of time, a rider mechanism can help facilitate staying out of a base rate case. So there's, it's a significant administrative burden coming forward with cases, and there are a number of different issues. And if you can isolate to the particular requirements associated with a unit, a rider mechanism may help facilitate that. In Texas, one of our other jurisdictions, there are rider mechanisms that are allowed statutorily, and so there are mechanisms that help to essentially bridge investment between rate cases, so that there's less frequency. Okay. There are 3 other bullets that are there. The SPS Renewable Portfolio Standard. We're recommending recovery of the Sandy loan unit to be recovered through the RPS mechanism. So in essence, it's an incremental cost that's associated with RPS compliance. And so gathering that cost impact in that rider mechanism was the rationale for presenting that mechanism, and kind of a natural place for recovery potentially of that unit. And then it included the fuel and purchase power cost adjustment. We have historically passed through production tax credits through the fuel mechanism. And Rick Fisher talked a little bit about that. Ryan Merrill talked about that a little bit in terms of the mechanism. That is the reason that some of the advantages of that mechanism for the PTCs is that we are looking to pass that benefit to customers as soon as possible. And then on top of that, we also have, you may have high wind years, you may have low wind years, solar is going to change. And because the credit is dependent on what actual production is, it's a better matching to have that trued up and pass that through to customers, as soon as possible based on, the actual production of those credits.
So if I understand you correctly, rate riders are good at recovering volatile, unpredictable costs or returning unpredictable benefits, like, for example, the production tax credit. Is that correct?
That's one benefit. Another benefit is the bridging of regulatory lag.
And is there any impact or disadvantage to the customer using a rate rider for self-build projects that are not volatile or unpredictable?
I tend to think, I tend to think that the rate riders are good mechanisms. They're essentially they're close to a formula rate in essence. But they are isolated to a particular asset and particular assumptions around costs.
So just a hypothetical example, if in this case, and it's one mechanism that hypothetical that you suggested in your testimony, if self-build project costs are recovered through rate riders, you're saying that has a benefit to the company because it avoids regulatory lag. Is that correct? In recovering those costs?
That's an advantage, for sure, of the mechanism.
And would you say that the countervailing impact of that advantage to the company is shifting risk away from the company to the customer?
I think it's a shared risk, right? So it is right, the same as there is timely recovery. So if we look at one jurisdiction versus another, how efficient is the utility at recovering their cost of service? Are there significant lags? Is there difficulty? Are there disallowances? all of those elements could potentially play into financing costs, which is not my area of expertise, but I understand that generally exists.
And are you currently aware, in an average residential bill, what percentage in New Mexico for average New Mexico residential customer, what percentage of that bill derives from rate riders versus the general rate, the rate class or the cost of service?
I don't have that statistic available right now, but that would be something that I could provide.
That's
if that
okay.
was
I'm just
important. Maybe I'd ballpark fuel. Fuel can make up a significant part of customers' bills. The percentage of a bill on a residential customer will be different than it is for a large industrial customer. On a large industrial customer, and depending on for instance, fuel rates, fuel volatility, things like that. But fuel could make up close to half of a customer's bill without looking at some of the other rate riders. Most of we have fairly small rate riders, but with fuel, you're probably looking at 15 to upwards of 50%, depending on the scenario.
Mr. Trowbridge, thank you again for all your professionalism and contributions to the proceeding. I have no further questions.
Thank you, Hearing Examiner Schaefer.
Thank you, Hearing Examiner Schaefer. I've got a few questions. Mr. Trowbridge, I guess since it's right in front of me, I'm just going to go ahead. Have you been following the hearing?
Yes, I have.
And I started out with Miss Lee's. She had attached SPS's 2023 IRP, the whole thing, to her testimony. And she had a pie chart and it's her attachment 1, and it's page 956 out of 1687. So it showed SPS customers by class, and then it showed New Mexico customers by class. It also showed the jurisdictional sales split. And at that particular time, the sales split I would represent to you for Texas was 47%. For New Mexico, it was 31%. And the wholesale was 23%. So
I'm sorry. Do you have a year associated with that?
Down at the bottom, it says note, data represents calendar 2022.
Okay.
Okay. And like I say, this is a page from the 2023 IRP. This is the only kind of representation that I could find that sort of simplifies what the percentages are in the SPS jurisdiction. Can you provide me with any updated information on those categories?
If you look at attachment AGT2 to my testimony, there's a simple table there that presents our forecasted energy share allocation between the
I'm
jurisdictions.
sorry, you're breaking up again. Simple
Okay.
table there that presents our
Energy allocation by jurisdiction, and our 12 CP or demand-based allocation per jurisdiction.
And what are those splits, sir?
Let me just pull this in front just so that I'm not blocking the audio. The energy allocator, that's going to represent to you, for instance, in 2030, that Texas represents a 41.46% share of the energy use on the system, while New Mexico represents 58.54% share. And I just went down to 2030 because that's where most of my bill impacts were created. If you move over to the 12 CP, that will show you the demand of those systems, which is about 44% Texas and about 56% New Mexico by 2030. If you went up to 2025, that would give you an idea that Texas currently represents about 54%. And then in 25, we also have wholesale as part of our system, but New Mexico represents 43% and wholesale represents about 2.5% of our system.
So then can I ascertain from this that the projections are basically within a year that the demand in New Mexico is going to outpace that of Texas?
That is what our projections are. And the details of that, John Goodenough will be able to provide more granular detail on that. But absolutely, we have seen substantial growth in New Mexico and continue to expect that. I actually went back 10 years. I went back to 2014, and substantially all of the growth that we've seen on our system. So we've seen wholesale decline significantly, but within our retail jurisdiction, all of the growth has occurred in New Mexico. So they've moved from about 900 megawatts up to about 2,000 megawatts contribution to our system peak.
What was the split in 2014?
So I don't have the wholesale piece, but we were at about from a retail perspective, we were at about 3,400. So 900 of 3,400. Let me do that. If you don't mind me accessing from a retail perspective, New Mexico was 26% share of our retail system.
So basically, 11 years ago, we went from, what did you say, 36?
Yeah, we've more than doubled.
26%. Wow.
Yeah. So we've moved
to in 2025 over 45%. Correct?
Yeah, exactly.
Okay. And also the little, on the next page of that particular IRP exhibit, it had sales by class. Are you familiar with that percentage?
Yes.
And basically, again, this says representing calendar 2022. It had 60% were large C&I. Small C&I was 25%. Residential was 14%, and municipal was 12. How have those numbers changed, and if so, how?
And do you have, so I do not have statistics, for instance, back to 2014 on that. But that's something that I would have access to.
Well, you don't have to take it back. Just tell me from 2022, from the pie chart I have, tell me whether or not it's changed. And if it has, are there corresponding changes like the one on your AGT 2, page 3 of 3?
I think the mix of customers, or the mix of sales and demand on the system, is continuing to shift. So I believe that our largest growth is occurring in the large commercial and industrial space. So that will be primary general, that will be LGST 69 through 115 kV, and 115 kV plus. And in this cost allocation, maybe something to point you to. I have something that reads 057 at the bottom of my PDF, and it's attachment AGT 3, and it says page 12 of 12. At the bottom of, at the very last page of attachment AGT 3, you'll see something that reads total allocation.
Mm-hmm.
And you can see LGST 115 kV plus, the far right column, you can see between 25 and 30.
Mm-hmm.
That as a percentage of the total system in New Mexico, they are moving from a 33.5% share of system cost, to a 50% or 49.66% share of system costs.
Under the current allocation methodology.
Under the AED4CP method of allocation.
Okay.
And that, right, and so I've I've kind of mentioned this, this is illustrative. This is kind of
right.
Mechanically, the methodologies that we typically deploy when we look at cost causation. But on top of that, you've got there's substantial latitude, obviously, by the commission to instruct what they think is appropriate.
And I can't find where the quote that I wrote down was attributed. but I have it right next to your quote that you've already been asked about with the potential 47% increase to the residential category. I have that right next to that SPS is going to have a 43% increase in load. If you know, does that 43% increase in load sound correct for the projects that have been requested? I found numbers of increases in your testimony, but I didn't find a percentage. So I don't think I got that from you.
All right. Do you mind if I use my phone calculator for just a second?
Please go right ahead.
Give you an answer here. Okay. So on attachment AGT2 at the top, what you will have is you will have 12 CP loads, which are a good proxy when we look at 1 CP and we look at 12 CP. The percentages don't really change that much. This won't necessarily show our 1 CP peak delta, but we can approximate this from a 12 CP perspective. So our forecast as a system was a 12 CP peak of just about 4,000. So let me just do this. By 2030, 5881 minus 409, 4049. Total increase over that 5-year period, about 1,800 megawatts of 12 CP. And then that divided by 4049, that's going to tell us a 45% increase, system increase. And of that, I believe that New Mexico represents 79% of that increase. Approximately.
Okay.
Yep.
Okay. Something else that I wanted to ask you about, Mr. Trowbridge, and it does sort of relate to that increase and your testimony. That I just turned over. Maybe you can help me. Do you know where you had the table of the proposed rate increases?
Yes. Page 37 of my direct testimony, and it is the second errata version. There's a table AGT1.
There. I had it on page 36. Okay, there it is. And just so that I'm comparing, if I can, comparing apples to apples, you label table AGT-1 average bill impact by class. And under the the first column is service class. The second is current bill. And then in parentheses, it says annualized rate. Is that correct?
That's correct.
And then you have proposed bill annualized rate, correct?
Correct.
Can you tell me the difference between the two of those? What is a current bill on an annualized rate, for example, for the residential class customer?
So for the residential customer, a current bill would have been our, at the time that I prepared this testimony, I would have had rates and riders in effect. These customers have a base rate. They have a seasonal base rate where they pay more in summer than they do in winter on base rates. So there's a seasonal variation in that. This reflects what they would pay on an annualized basis. So if I took total monthly, or if I took a total year and I divided by, well, let me say that again. Take the sum of winter months at winter billing rates. I would take the sum of summer months at summer billing rates. And then I would take the sum of all of that and divide by 12. That would be representative of a current annualized rate.
And that includes your, what I refer to as your customer charge?
Yes.
And the riders, I think you indicated, and then and then also the commodity charge, right?
That's correct.
Okay, so their total bill.
Total bill.
Take 12 months of it, divide by 12. Now, this particular residential customer, was it a high usage, low usage, average use customer? Whose bills did you annualize?
So this is an average customer.
Okay.
So this is approximately 900 kWh monthly usage for customers, and so that is very close to what I've anticipated averages for customers
For the residential class.
For the residential class.
And this proposed annualized rate under this average bill impact, that would be in year what?
2030. So that is full deployment of all of the self-build resources, and those resources being deployed for a full annual revenue requirement.
And the current bill annualized rate was when you did your testimony?
Yes.
Okay. Which was what, approximately September of last year?
I think that that sounds about right. I think it's still reflective of, but I don't think that the current bill would change significantly from where we were 6 months ago.
Okay.
For instance,
And I'm
or whatever it was. Yeah.
and I'm not trying to suggest that it's not. What I'm trying to do is get in my head. So did you file testimony in case number 025-00079? which is the current rate case?
I did file testimony in the current rate case.
Okay. So I'm looking at I'm not assigned to that case, but I'm aware that it exists. And I've got a copy of what I believe was, I think, attached to the application. It's called a proposed notice to customers. And I'm looking at something called an average bill impact summary, present to proposed. And it represents the customers in groups of low, average, and high. And under the residential average, I've got I don't have an annualized bill. I have I guess I have what's called a current summer bill that was $131.01 for summer and $113.40 for the current winter bill. And overall, I have percentages of changes to that bill. And I was just trying to figure out, and looking at this and then looking at your testimony, you did not, when you were using your table, you did not use the proposed increases that SPS has requested in its rate case, did you?
No, because that filing would have come after this testimony.
Okay. Well, do you have a feeling based on I think it's a 24% change proposed in summer and a 32.5% change in winter. Again, I'm just talking about that residential customer. And then I believe SPS is also proposed, I called it customer charge. You call it a service availability charge. And this is, I tell you what page, but there's no page on the proposed notice at the bottom for me to tell you. So I'm just going to tell you, it says that the current service availability charge is $11.20. Does that sound about right?
I don't have those numbers in mind, and I don't have that in front of me. But if you say that that's what it is, then I believe you.
Okay. Well, again,
check.
it's right. It's SPS's exhibit, so to their rate case, and it looks like in the rate case that the SPS has proposed a $21 service availability charge, or an increase of 87.5% in that. So my question is, if SPS gets the proposed increases in its service availability charge, and then the other increases that were proposed in the KWH, or proposed increases, then potentially your table AGT-1, the average bill impact by class, is going to be low, isn't it?
So a couple of thoughts.
Okay.
All right, a couple of things that I'm thinking about here. One, what I presented is a at the time current bill versus proposed bill. And we are truly just isolating the increase in revenue requirements associated with the self-build projects. partially offset by sales growth. So we are looking at 2030, for instance. A second item to note here is that we have a grid modernization charge. And so we currently have a rider mechanism that's in place that we're actually rolling those costs under rate base, base rate. So there's actually a shift that's taking place that you probably can't see on the surface there, where they're seeing a decrease because the rider's essentially going to zero. And then we're increasing, for instance, the service availability charge to reflect the increase in investment. And so grid modernization is not, it's not entirely associated with the service availability charge, but a lot of the increase is due to AMI metering infrastructure. So there's a shift that's occurring there from a service availability charge, but you can see that the current bill is still, and I wish I had that table in front of me, but you can see that the current bill is still, and it should be weighted higher toward winter months because there's 8 winter months and 4 summer months. But if we were to look at the average of that, I think that you're probably still reasonably close to that $130 mark. So that said, your point about this bill impact not holistically expressing other rate request is accurate, right? So if we've requested, and I don't know what the number is, but if we've requested 20 something percent increase in residential service, then there, we have to get through the rate case, and there are particular requests that are in there. But there are other rate pressures other than just this generation portfolio, as you probably know. So hopefully that was helpful to kind of navigate at least a couple of those issues.
I am just again trying to put it in context here to make sure that what we're looking at is the same thing, or if it's different, and what time period it's applicable to. It's when there's so much information about the rates and they're presented in different forms.
Yeah.
It can be confusing.
I think if you looked at my direct testimony in the rate case, you would see a presentation that was similar to what we've presented here.
I'll leave that to hearing examiner Schaefer to figure out. That's his case. Very well. Let me just look through my notes, sir. I believe that's all I had for you. I think we went through what happens when you ask people for bench requests, they give you responses, and then You start losing them. And just to make sure, you were a respondent to bench request number 1-2. Please provide the jurisdictional allocation percentages for generation costs included in this proceeding. And you refer to AGT2 attachment. And I think you've been asked some questions about it. And then with response to bench request 1-4, please provide the benefits of Sandy Loam Solar. And you were one of the sponsors to that also, weren't you, Mr. Trowbridge?
Yes.
Okay, very well. I don't have any further questions for you. I appreciate your time, sir. Ms. Hardy, any redirect for Mr. Trowbridge?
Madam Examiner, I do have some redirect, but given the lateness of the hour, I'm wondering if I might be able to do it tomorrow morning, because I expect there may also be questions from other parties given the amount of topics that Mr. Trowbridge has discussed this afternoon.
Okay. Is there any objection to us recessing then for the evening? We'll come back with redirect and any possible questions. And then I believe Ms. Hardy will hear from Mr. Goodenough. You can tell him he's not going to be admitted. We'll see him in the morning. And then after the presentation of Mr. Goodenough, I believe that leaves us 2 SPS witnesses that are not available until Wednesday. Is that correct?
That's correct, Madam Examiner.
Okay. So therefore, what I would see then, based upon hearing examiner Schaefer and my ruling at the beginning of our hearing last week, is that we will proceed to hearing from staff. And my understanding is that that staff requested Mr. Malden to be first, and then did not have a preference. Is that correct, Ms. Amer?
Yes, that is correct. And we still have Mr. Cunningham, is that correct?
Yes, tomorrow. And
And-
we'll finish up with Mr. How soon they forgot Mr. Trowbridge.
Yes.
So you want Mr. Malden first, and then shall we go with
Might I suggest Mr. Malden and Miss Leyva Tesoro, and then Mr. Zigich and Mr. Whitney?
okay. There's not very much cross-examination time for the staff witnesses. So I believe, depending on availability, we would go back to our order of intervention and begin with the witnesses in that order. Okay, any other procedural matters we need to discuss?
No,
Hearing
Madam
examiner Schaefer, Ms. Hardy.
Sorry, I think Ms. Amer had asked about Mr. Cunningham, but he will be testifying on Wednesday.
Sorry,
yeah,
you're right. Mr. Goodenough is
tomorrow.
next after Mr. Trowbridge. Mr. Cunningham is the one that's in the snow.
Right.
Without his laptop.
Yes.
So he's not available until Wednesday, along with Ms. McCardle. Okay.
Right.
Let me just also, before I forget, SPS did serve its response to the third bench request. And if I see this correctly, I can actually get to that screen. It's my understanding that SPS is making the representation that this suffices for bench requests 5, 6, and 7. Is that right, Ms. Hardy?
I believe that's correct, Madam Examiner.
So that just leaves us 8, which was the one that was asked today to provide the renewable material purchases along with, I think 7 was just gains, and 8 is provide the same information for Tolk and the renewables.
Correct.
Okay, so that's the only one outstanding.
Yes.
Okay, Ms. Amer.
Yes. Now I'm gonna forget what I was gonna say. Great. Okay, so I think we just forget it because I can't remember now, sorry.
Okay, you can take the little hand down. All right, if we don't have anything else,
I'll just say,
Hearing Examiner
we
Shaper.
discussed on Friday, some of us have some mics that are not as strong as others. Miss Amer, I would just maybe suggest trying another mic or something, because I value everybody's contribution, and sometimes it just gets a little hard to hear you. So
Okay.
thank you for.
Is it better now?
Yes, but I don't want to have to force you to lean in all the time during your testimony. So it's better when you're really up close, but I know that that might not be comfortable for long periods of time. So just some thoughts from the hearing examiner side.
All right, I will try. I have I'm having a little technical difficulty attaching my speakers, so it's having to come out of the laptop.
No worries. Just wanted to share that.
Okay.
Thank you. Thank you, everybody.
Thank you
Thank
all.
you.
Thank you, Mr. Lee. We are recessed until 9 o'clock tomorrow morning. Thank you.